Good morning. Welcome to the 2017 Fair Housing and Lending Seminar. My name is Scott Dean, and I'm Chair of the City of Columbia's Human Rights Commission. I would like to introduce Second Ward Councilperson Michael Trapp, who will present the Mayor's Proclamation.
I do have a few remarks before I get to the proclamation. I too would like to welcome you to the City of Columbia's Fair Housing and Lending Seminar. Decent, affordable housing for all of our citizens is a fundamental to a thriving, safe, and healthy community. Fair housing and lending is critical to building the community we want, to making the City of Columbia the best place to live, work, learn, and play for all of our residents. In the fall of 2015, the City of Columbia adopted a new strategic plan. Since that time, we have continued to focus our efforts on creating more living wage jobs, strengthening our community so that all individuals will thrive, improving our citizens' satisfaction with public safety, connecting the community through infrastructure, and achieving operational excellence for all of our citizens. We're into the strategic plan enough to where we're starting to see some data, and we're starting to move population level data in regards to crime rates, in regards to the African American poverty rate. When you focus on something, when you measure it, when you put the power and resources of city government behind something in partnership with the community, with the people that we serve, you can see real change, and we're seeing that. On behalf of Mayor Treese, I'm going to present the Mayor's Proclamation. Whereas on April 11, 1968, the Fair Housing Act was signed into law by President Lyndon Baines Johnson, and whereas a strong community requires quality education, good jobs, and a sound financial base, which all start with access to decent, affordable housing for all citizens, and whereas discrimination in housing or lending and homelessness negatively impact the overall well-being of the community, and whereas Chapter 12 of the City of Columbia Code of Ordinances makes it unlawful for any person to discriminate in housing or lending against an individual because of that individual's familial status, race, color, religion, sex, national origin, ancestry, marital status, disability, sexual orientation, or gender identity. And whereas the City of Columbia's 2016 to 2019 strategic priorities include social equity to strengthen the community so all individuals thrive by supporting neighborhoods, increasing home ownership, and increasing the stock of affordable, energy-efficient, and universal design homes. And whereas the City of Columbia, Missouri is committed to the issue of fair housing for all of its citizens. Now, therefore, I, Brian Treese, Mayor of the City of Columbia, Missouri, do hereby proclaim April 2017 as Fair Housing Month in the City of Columbia, Missouri. And before I thank some of the folks who were involved in this, I'm going to kind of go off script. Sorry, Rose. And you know, it's just so many folks who are interested in fair housing have gathered. One of the proudest things that I've done as a council person was champion our really groundbreaking ban the box ordinance to stop discrimination against people who have criminal records in regards to hiring. And it's very simple. It says before you can ask someone about a criminal offense, you have to make them a provisional job offer. So you have to bring them in, you have to meet with them. You just can't put it on an application and trash can the application because of something that may have happened a long time ago. And in best practices in hiring, then we know that questions about criminal background are appropriate. And you can use that to determine, and employers have a fundamental right to hire whomever they like or not, without using discriminatory practices. But the best practices is that questions should be offense-specific and not sweeping, and that there should be a time limit in regards to some offenses, and you should be able to offer some evidence of rehabilitation. And one of the reasons that it's a best practice and that even without the force of law, many employers had moved towards this is because there's some risk that because of racial disparities in regards to who has police contact and racial disparities of who has contact, who gets arrested, and racial disparities of who gets arrested, who gets charged with what. And there are racial disparities with who pleads out to what, and what happens at trial. And all of those racial disparities pile up to where we see very much that felony conviction can be a proxy for race. And that puts people at legal peril. And so it's better to avoid that whole thing by bringing in those best practices that I mentioned. So I'm not a lawyer, and I know that people are getting legal credits, but I just want to put out there that I think the safest way is to look at like what the Housing Authority does, to have a very reasonable approach of kind of who can get in the door, and then have a zero tolerance, because people demand in this community that we keep our housing safe, and landlords have a responsibility to be part of that solution. But that idea of I'm much more concerned about what people are going to do than what they did in the past. And the past is not always a great indicator of the future. So just something for you all to think about for those of you who are players in the housing field. I also want to recognize Rigel Oliveri, Amanda, boy, I wish I'd have got some pronunciation advice before I got into this. Amanda Biondolino, Dr. Molly Metzger, and Randy Cole. I know I got that one. And thank them. These speakers have volunteered their time to share their knowledge and expertise with us today. I'd also like to thank the sponsors of the event, the Missouri Commission on Human Rights, Columbia Housing Authority, Columbia Apartment Association, Central Bank of Boone County, and the City of Columbia Human Rights Commission and Disabilities Commission, the city staff and their departments for their contributions to today's program. Most importantly, I would like to thank you for attending this program and showing your commitment to fair housing and lending and building a better community in Columbia. I hope you enjoy the program. Thank you.
Thank you, Councilperson Trapp. Before we get started with the introduction of our first speaker, I have a few housekeeping matters. We have a microphone set up for questions right there in the center aisle. Each speaker has allotted time at the end of their presentation for questions. If you have a question, please jot it down and then come up to the microphone to ask your question when that time is made available. Bathrooms are located in the lobby to the right, just past the information desk and the big robot. Refreshments and snacks are located in rooms 1A and 1B, which is to the left as you exit the council chambers. There will be a snack break at 11:15 to 11:45. Your materials include a survey. Please complete the survey and return it to the registration desk or at the back of the room as you leave. We appreciate your input and use your input to plan future seminars. And finally, please silence cell phones while the speakers are presenting. Okay. With those preliminary matters, I now have the honor of introducing our first speaker. Our first speaker is a nationally recognized expert on fair housing laws. Professor Rigel Oliveri graduated from the University of Virginia and then attended Stanford Law School. She worked as a trial attorney for the U.S. Department of Justice in the Civil Rights Division, Housing and Civil Enforcement Section. She litigated a number of significant cases involving housing discrimination and sexual harassment in housing. In 2003, the Attorney General of the United States awarded her a special commendation for outstanding service. She joined the faculty at the University of Missouri School of Law in 2005. Her scholarship focuses on housing discrimination, residential segregation, zoning and property rights, and sexual harassment. Her work has been published in many scholarly publications, including the Stanford Law Review, the Harvard Civil Rights, Civil Liberties Law Review, the Florida Law Review, the Wisconsin Law Review, and the Vanderbilt Law Review. Let's welcome Professor Oliveri.
Hi, everyone. Thank you for that introduction, and I want to thank the Rose Wibbenmeyer and the City of Columbia for putting on this program. I enjoy speaking at this program every year because, as you could probably tell from that little bio sketch of me, I'm very invested in fair housing. I think it's incredibly important. I think it's incredibly interesting, and I think it touches on so many areas that we can have really interesting discussions about. So many different aspects of it. It's going to be hard probably for me to keep my remarks short, but my goal in this is to give you kind of an overview of the law, what the law is, what it covers, some recent developments in the law, And then I'll leave some time for questions after that. So I'm going to pull up my... So, yeah, I'm really going to try to condense what could be an entire semester's worth of a course at the law school into about 35 minutes or so. And I will welcome your questions afterwards. So one of the things that I want to start off with is, not in my PowerPoint, which is just for us to think for a minute about why April is Fair Housing Month. It is, as we heard in the proclamation, it is the month in which the Fair Housing Act was signed into law by President Johnson in 1968. And so that's why we have April as kind of our annual celebration of fair housing. But I want us to also think back. The bill was signed into law on April 11th. The Fair Housing Act had been proposed and had failed in Congress the year before. It was stuck in committee for many months, and it looked like it wasn't going to pass for a second time. And something happened on April 4th of 1968, which sort of helped move the bill forward. And that was, of course, Martin Luther King Jr. was assassinated. Now, one of his final things that he'd been working on at the time of his death and in the months leading up to it was advocacy for what he called open housing, but what we call fair housing. He'd been leading marches in Chicago. He'd been pressing for the bill to move forward through Congress, and had been one of sort of the cornerstones of his sort of, after the passage of some of the early civil rights bills, this was the next one that he'd been working on. And he was finding it really hard. Like I said, the Fair Housing Act didn't pass the first time around. There was a lot of violent kind of pushback to it. And so I think it is, and it's a very sad fact that it almost took his death to help move it forward when it was sort of stuck in committee in Congress. And so I think putting it into that context is kind of an important thing to think about, that this wasn't something that was just a given. This wasn't an automatic kind of course we should have this law. It took a lot of hard work to get this law passed. And I don't think we should take any of it for granted today. And in particular, I bring this up because if we look at where we are today, things still aren't great. They're certainly better. I'd say in many ways, we've progressed a great deal from the mid-1960s when this bill was the Fair Housing Act was having such a hard time getting passed. But passage of the Fair Housing Act certainly didn't mean that housing discrimination vanished overnight. The most recent statistics that we have are from 2015, and they show that there were almost 28,000 reported complaints of housing discrimination. And these are complaints that are made to either federal or state or local agencies or to private fair housing groups. And of course, these are only reported complaints. So this is only people who recognized that they were being possibly discriminated against and had the wherewithal to report it and knew who to report it to. So we all know that that's a real underrepresentation of the actual amount of discrimination that is out there. And most people who specialize in this kind of statistical modeling come down to the conclusion that there's probably about 4 million instances of housing discrimination just in the rental market alone every year. That 28,000 figure probably translates more into something like 4 million when you think of all the people who didn't know they were being discriminated against or didn't know how or to whom to report it. So that's it's a depressing statistic. And then when we add in all of the demographic data about rates of residential segregation, things are fairly depressing there too. While our segregation patterns, at least in terms of racial segregation, have decreased somewhat since the 1960s and 70s, they haven't decreased all that much. And when you look at sort of neighborhood segregation rates, you see that they're still extremely high. In basically every American city today, the rates are significantly higher than most experts would say is sort of normal or healthy or is something other than the product of a longstanding history of discrimination. So there's still vestiges just in the patterns of where we live. And this is all incredibly important because, of course, as we'll talk a lot about today, and all the speakers will, housing is so important. Kind of where you live makes a huge difference to just about every aspect of your life. Where you go to school, whether you have access to green spaces or healthy food, how the kind of access you have to things like public transportation, job opportunities, just general safety. All of these things are important. The physical space of your house is important. We know that, right? I mean, that's where we put our kids to bed. It's where we come home to at the end of the day. So having a house or an apartment that suits your needs is crucial. And having it be in a place that is a positive, healthy environment where there's opportunities and amenities is incredibly important too. So I kind of lay that groundwork to contextualize what I'll talk about today when I talk about the law, because law can be kind of dry, and I think it's important to remember what animates the spirit of this law. Okay, so I'll be talking about the Fair Housing Act, and I'm going to start just by kind of talking about general coverage. What is the Fair Housing Act? What does it cover? Who does it cover? The Federal Fair Housing Act, which of course applies to the entire United States, and I'm going to start with the characteristics that are protected first. It's a little bit of a weird way to go about it, but hopefully it'll make sense in a minute. The characteristics that are protected by the Fair Housing Statute are race and color. A lot of times those are sort of just viewed together, but the statute does separate them out. National origin, which is also sometimes referred to as ancestry. Sometimes people think of it as ethnicity. Religion, sex, and then sort of the last two, those were in the original statute. The last two were added in 1988 when the statute was last significantly amended, and that is familial status, which means having a custodial relationship over a child under the age of 18, or if a woman is pregnant. And this is kind of a unique thing. Most civil rights laws don't contain this as a protected category. It was put in there because there was found to be pervasive discrimination against families with children in housing. And then the final one is handicap, that's the language the statute uses. The preferred nomenclature today would probably be disability. I'll probably interchange the two when I'm talking. And again, that was added in 1988, which is actually 2 years before the Americans with Disabilities Act. So the Fair Housing Act was actually out in front of, at the forefront of the disability rights movement. And again, there was very good reasons why this was added to the statute at the time, because housing, the physical structure of housing, is so important to people with disabilities. And there, again, was found to be pretty pervasive discrimination against disabled people in housing. So that's what's in the federal statute. Those are the characteristics that are protected. The first four, sort of race, color, national origin, religion, and sex, those characteristics are protected. So it means you can't be discriminated against on that basis, no matter which group you are in. And I think that's kind of important. Obviously, the civil rights movement and the passage of the Fair Housing Act was done in the context of sort of race discrimination against African Americans, but people of all races are protected by this. People of any national origin are protected, any religion or lack thereof. So you don't have to fit into a particular group in order to have the protection of this statute. These are just the characteristics that discrimination is not allowed to occur based on. The last two, familial status, you only qualify for protection in that if you have children under the age of 18 living in your house. And obviously you only qualify for disability, to make a claim under disability if you are in fact disabled or regarded as being so. So those two only kind of protect people who actually fit into a specific category. But the first ones protect everyone, because I often get questions, could someone be discriminated against for being kind of in the majority group? Sure, the law would protect that. Okay. Columbia, the city of Columbia, adds some additional protected characteristics. Sort of the state law in Missouri pretty much mirrors the federal law in terms of the characteristics that are covered. But Columbia, as a city, has added additional protected characteristics. The most significant of which, sexual orientation, gender identity, and marital status. Other areas in the country, other states and other cities will sometimes add additional protected characteristics as well. So sometimes you'll see things like age, military status, status as a student is one that some places add into theirs. So, municipalities and states can add to the protections that the Fair Housing Act has, but of course the Fair Housing Act as a federal statute applies everywhere, so it's kind of the floor, and places are free to add to it as they wish. So get into what is actually covered in terms of what is prohibited conduct by the statute. I've got the main ones kind of set up here, main portions of the statute. I've got the numbers there are the statutory sections because I'm a lawyer and the statute is important to me. But I'll just run through briefly what you're not allowed to do, or what housing providers or landlords or other people who have control over housing cannot do under the law. And probably the most important one is this subsection A at the beginning, which makes it illegal to deny or make housing unavailable to people because of a protected characteristic. All of these sort of are illegal if they're done because of a protected characteristic. So that's probably the biggest one. And it can really sweep in all sorts of things. Anything that someone can do that will have the result of denying someone housing, be it refusing to deal with them at all, be it evicting them, what have you, can be encapsulated in that subsection. It's also illegal under subsection B to discriminate in the terms and conditions of housing. So having different rental rates, having different requirements for creditworthiness when you're taking an application, all sorts of things can count as different terms and conditions of housing. One important thing that I will mention with this subsection is that this part has been interpreted to also include how people are treated while they are tenants of housing. So it includes things like harassment based on race, religion. Sexual harassment is kind of a big area, and it's one that I'm particularly interested in my research. And so it is seen, the way the law views it, is that if a person is being harassed because of a protected characteristic, they're actually being exposed to different terms and conditions in their housing than someone else who doesn't have that characteristic and who's not being harassed as a result. So there's a lot of cases that can be brought under that subsection. Subsection C prohibits discriminatory statements, advertisements, and notices. So that's not as common anymore. Used to be, in the 1960s, there was a very salient reason for having this, because people would have whites-only signs and things like that. Today, we don't see that as much. One area where it has surfaced has been in online venues where housing is advertised, like Craigslist and things like that. So it kind of, it sort of stopped back in the 60s with the passage of the Fair Housing Act, and it's kind of, because housing providers, learned the law, knew that this was a prohibited thing to do. But then as kind of housing provision has gotten more democratized and people are using the internet more, we've seen kind of a resurgence in cases of that happening. Subsection D makes it illegal to misrepresent the availability of housing. And now this, it can be subsumed under subsection A, right? If you tell someone housing isn't available when it is, you're denying them housing. The reason the law wanted to make that a separate section, the reason Congress separately broke that out, is because that also covers fair housing testers. One of the big ways that fair housing laws are enforced and fair housing violations are detected is by fair housing groups usually sending out testers. Because it is so hard to know, if a person goes and applies for housing and they're told, oh, we're sorry, the last unit's been rented. You may have no reason to think that that's not true. and you may walk away thinking, oh well, too bad that place isn't available. The only way to determine whether or not that was a truthful statement sometimes can be if a tester gets sent in shortly thereafter to make the same inquiry and gets told different information. And so fair housing groups have made use of testers and large-scale testing projects, both just to measure the amount of housing discrimination that's going on, but also then to serve as the basis for enforcement actions as well. And it's proven to be a really valuable tool. Other things that are unlawful are discriminating in sort of housing-related services, brokerage services, real estate services, lending, appraisals, financing, things like that. And then there's another section of the statute that specifically makes it illegal to harass, intimidate, or coerce people who are trying to enjoy their rights to fair housing. And that's another kind of anti-harassment measure. All of these things are illegal when done based on protected characteristics only. So of course you can deny or make housing unavailable to someone based on other reasons, inability to pay or something like that. All of these things are only illegal when done kind of for the because of the person's protected characteristics. Like I said, sometimes that's not always easy to ferret out what the motivations of a person are, but that's the way the law is structured. There are some additional protections in the law that are specific to disability, and so I just want to talk about them separately because they only apply to the disability protections. And disability has been consistently in recent years one of the protected characteristics about which the most complaints are filed. So it's really a big area in the law. And these requirements in the law have a couple of specific things. They require reasonable modifications to be permitted to a dwelling if someone needs those to use and enjoy the dwelling. So a very common example of that would be someone who uses a wheelchair asks their landlord, is it okay if I put a ramp in so that I can get in and out of the house? The landlord should grant that request. That is a reasonable accommodation. And it's necessary for that person to be able to use the dwelling. You also need to be, or a housing provider needs to also provide reasonable accommodations to rules and policies when those are necessary for a person to use or enjoy a dwelling. And the really most common examples of those things would be an apartment complex has a no pets policy, but someone has a service animal. Now there's an argument, there's a discussion in sort of the fair housing world that, service animals aren't pets, so they're not even covered by the no pets policy. But, if we assume that the policy is something like no animals allowed, a modification or an accommodation needs to be made to that policy to allow someone to have a service animal. Other examples that often come up are things like there is assigned parking spaces, but someone needs a parking space that's closer to the building. And so the landlord needs to make a change to the normal policy of how parking spots are assigned, something like that. This can also apply, and has been applied very commonly, also to decisions by zoning authorities when they're permitting group homes. A lot of zoning rules don't allow more than a certain number of unrelated people to live together. But a lot of people with disabilities benefit from living in group homes, depending on the nature of the disability. And so zoning authorities need to be willing to grant, to be flexible and to grant variances or permits for group homes to operate. And that's also viewed as being sort of a reasonable accommodation to existing rules and policies to allow that. And then the final area is there are actual physical design and construction requirements for new multifamily housing that's covered by the statute. There's some complexities there, but that actually require buildings to be constructed in a way so that they're accessible and usable by people with mobility impairments. This stuff gets kind of technical, but at base, it's really allowing people to use dwellings, making sure that hallways aren't too narrow for wheelchairs, making sure that doorways aren't too narrow for wheelchairs, making sure that the light switch isn't too high for someone in a seated position to reach. Really basic things that allow people to use housing eliminating sort of physical barriers that don't need to be there, as long as sort of basic design and construction requirements are followed. Okay, so that's the law, that's what it covers and who it covers. I want to talk just a minute or two about some of the theories, the legal theories that are used when bringing any discrimination case. And so this would apply in, employment discrimination, other areas as well. And there's sort of the two big ones. There's disparate treatment, which is intentional discrimination against people based on the protected characteristic. So you have two people who are the same but for the protected characteristic, and you treat them differently. There's a notion that this is intentionally done, sort of deliberately done. There's a lot of new studying and information being done about implicit bias, which is to say that it may be possible, and it looks almost certain that we sometimes treat people differently without even meaning to, just based on some of our subconscious or implicit biases. But in any event, it is the notion that sort of there are two people who are the same in all other respects, but one, and they're being treated differently as a result of that. So it's kind of our classic view of what discrimination is. Two applicants for housing, one black, one white. The white one's treated more favorably. That would be disparate treatment. Like I said, that is certainly very common. It certainly happens, as the statistics I brought up earlier indicate, quite frequently. It's also sometimes hard to prove without testing data, without some smoking gun or something like that. It can be difficult to prove why someone's taking a particular action. But it certainly is kind of a clean, classic view of discrimination. I think it's one that most people can get their head around. The second kind is kind of a newer development in the law. I mean, I say new, it's 40 years old by now, but it's sort of something that has been developed through the court system. And that is the notion of disparate impact, which is to say that it can be a violation of the law, it can be discrimination, to even have a facially neutral policy, but that affects different groups of people differently when there's no good reason to have that policy, when there's not a justifiable reason. Examples of that might constitute something like saying, I want to have a limitation on the number of people who can live in a dwelling, and it can't be more than two. That may look facially neutral, but that's going to discriminate against families with children. If you've got a two-parent family, that would prevent them from having children living in their household. So that's one example, but there are many, many others where a policy is being adopted that has an impact on a group of people. Some of the ban-the-box stuff that we were just hearing about is a similar thing. If a landlord has a policy where they won't even consider someone for tenancy if they've ever been convicted of any crime, or if they have any kind of criminal history, that's going to affect certain groups of people more harshly than others. And now, there may be reasons, they may be justified or not, but the fact that the policy has an impact is kind of the thing that opens the door in terms of the legal theory. Once we demonstrate that there's a disparate impact, then we can talk about whether or not the policy itself is justified and should continue regardless. In fair housing cases, there's also another aspect to this, which is really interesting, which is that disparate impact claims also include claims that a policy or a practice is entrenching or increasing existing segregated patterns. And this is where things can get really kind of interesting on a big picture level, because it implicates actions by zoning authorities, people who are deciding how to use community development funds, things like that. So it can implicate kind of institutional actors more than just kind of at the individual landlord. It can actually apply in some areas that affect whole communities. And courts have been willing to look at it in that way. So I want to talk a little about some recent developments that the law has had. For a long time, I mean, since the Fair Housing Act was amended in 1988 to include those additional protected characteristics, but then for a long time after that, it just kind of stagnated. It was being enforced by various groups and all of that, but the law itself kind of didn't change much. When I taught fair housing law, I could kind of use the same set of notes over and over again because nothing changed. And then in 2015, some big changes happened. It was pretty exciting. Fair housing got a moment in the sun again. And there were two major changes. One was the Supreme Court of the United States endorsed the use of disparate impact theory for fair housing cases. So when I was talking earlier about how that is an available theory, it was one that the lower courts would use, but the Supreme Court had never said whether or not it was cognizable under the Fair Housing Act. It had come up a few times, but the court hadn't decided it. And so in 2015, the issue got presented to the court, and the court squarely decided, yes, disparate impact claims can be brought under the Fair Housing Act. And the context in which this happened was also particularly significant. This was a case that came out of Dallas, and it involved kind of municipal actions that were increasing or entrenching existing segregated patterns, particularly through the use of low-income housing tax credits and things like that. The city of Dallas was doing things to make sure that low-income housing continued to be built in areas that were almost completely minority, and that sort of no low-income housing was going to be built or subsidized in areas that were not significantly occupied already by minorities. So that fact pattern is something that can happen kind of all over the country. And when that case came down, it was kind of a wake-up call to a lot of, I think, zoning and planning authorities that they need to be more conscious of these things, the decisions about where to locate housing and where to allocate development dollars and things like that. So it was a pretty big deal. Closely on the heels of that came some action by the Department of Housing and Urban Development. They passed a rule that was kind of a while in the making, but it came down kind of, I think, within the same month as the Inclusive Communities decision did, which in some ways was largely symbolic, but in other ways it has some very practical effects. And it's called the Affirmatively Furthering Fair Housing Rule. It's kind of a weird mouthful. But in essence, the Fair Housing Act actually contains some language that says that the statute should be applied in a way that affirmatively furthers fair housing. And HUD, in a lot of its various regulations and rules and statutes that govern it, also says that HUD action should be done in a manner which affirmatively furthers fair housing. What that means has been something that the courts have had to decide over time. And courts have come to the conclusion that that means not only just making sure that, when an agency is taking HUD dollars, they're not being discriminatory, but they're actually affirmatively trying to break up segregated patterns. So in particular, this comes with entities that receive community development block grants. As virtually every place in the United States gets that money. For a long time, those monies were being received by municipal entities to kind of do whatever they wanted to with. I mean, they had to, obviously, I'm sure that there are people in this room who could describe all the hoops that one has to jump through when getting those funds. But as far as fair housing went, for a long time, you just sort of checked a box to say, yeah, we're doing this in a way that is consistent with fair housing. The Affirmatively Furthering Fair Housing Rule that HUD came down with in 2015 actually requires entities receiving this kind of money to actually go through a pretty extensive process to make sure it's being used, and it really is being used in a way that doesn't entrench segregated patterns. So money isn't just being taken to kind of dump low-income housing into minority areas. That actual thoughtful process is being engaged in to make sure that there are a variety of housing opportunities and housing types and choices that are being, moved throughout the community. And there's data tools and statistic tools and things like that that the rule makes available to cities and municipalities that are having to do this process. In general, what the affirmatively furthering fair housing rule also did was just kind of affirm a commitment on the part of HUD to try to break up segregated patterns, to try to at least be thoughtful about it, instead of kind of allowing the patterns to continue and allowing federal dollars to subsidize them. So it had a big symbolic import, but then it had some practical aspects as well. Okay, so I will leave some time for questions, but before I do that, I want to kind of talk about what's next, what's coming in terms of fair housing. The rule that I just talked about, the affirmatively furthering fair housing rule, was criticized fairly directly by the person who is now the Secretary of HUD. Ben Carson, at the time it came down, wrote an op-ed where he said, I don't think we need this rule. This is not a good rule. Now he's the Secretary of HUD. So, it's not so easy to just undo a rule once it's gone through kind of the regulatory process, but it may be that HUD's kind of commitment that it voiced in 2015 to this may kind of be pulled back in terms of its enforcement and its sort of just overall institutional commitment to this. It remains to be seen. The other area where there's been some interesting, very recent development, so recent that it was like this week, is in the area of lesbian, gay, bisexual, and transgender rights. And if you'll recall, those are not protected characteristics under the federal statute. They're not protected characteristics under Missouri's state statute. Heretofore, most courts that have ever kind of heard a case alleging discrimination against someone on the basis of their sexual orientation or gender identity without having a specific protection in the statute, most courts have said you can't make that claim. If it's not a protected characteristic, you don't get to make the argument that you've been discriminated against on that basis. This week, 2 courts have held that discrimination on the basis of sexual orientation or gender identity actually constitutes sex discrimination. The Seventh Circuit Court of Appeals, en banc, which is the entire court, all of the judges that sit on that court, recently found this in an employment discrimination case, but it was a similar, protected characteristic. They said discrimination based on sexual orientation and gender identity actually constitutes sex discrimination. You're being discriminated against for not conforming to the expectations of someone of your sex, and so that can kind of be folded in. And then it was either yesterday or the day before, a court in Colorado found the same thing with respect to the Fair Housing Act. A district court in Colorado said the same thing it was a couple in which one of the members was transgender, and so it was a cis woman and a transgender woman in a couple. They were alleging discrimination either based on sexual orientation or on the transgender status of one of the members of the couple. The court there said that constituted sex discrimination and allowed them to state a claim. I don't know if this kind of is opening the door for more cases like this. It certainly is a big change to the existing law, which for decades was never viewed this way. It's probably something that at some point would need to go to the Supreme Court. Of course, all of this assumes that the laws themselves aren't amended to include these categories, but I think it's safe to assume that's probably not going to happen anytime soon. So now the action is in the courts and what they do with it. And really, this last week was the first time the court seemed to really move in this direction. So that's something to keep an eye out for as things go. Certainly when things work their way through the courts, it takes a while, but like I said, it's certainly something that I and other people in the fair housing community will be keeping an eye on. Okay, so I wanted to leave plenty of time for questions based on anything I've talked about. So we've got about half hour. I don't know if you want to come to the mic. I think they want people to do the microphone if possible, but I'm happy if you shout out your questions.
So I'm kind of a baby in this area, just learning, but I doing housing intake and I have a case where someone is their bathroom door is not big enough for their wheelchair to go through, and I've been in touch with legal services about it, and they said that the obligation of the housing authority is different than the obligation of a private rental place. So I just wanted you to talk a little bit more about that so I could understand that.
Sure. So the design and construction requirements that would require doors to be certain width or hallways, and a variety of other things too, they apply to certain types of housing. So it's multifamily housing that's constructed for first occupancy after 1992. It has to do with, whether it's a ground floor unit or whether there's an elevator in the building. So there's a variety of coverage things that apply to the construction of the housing. So I hate to kind of speak on something if I don't know all the facts, but if this was housing that was built before then, it may not be covered by that. And so, whether or not it's subsidized may not even be really the issue. It's more, it is very hard to go back and retroactively do things like widen a hallway or a doorway. That's why the statute is written to apply to sort of new construction. So it may be something that's not within the coverage. I don't know.
So the legal aid
And that may very well be true. Under the way the statute's normally written, the tenant would pay for the modification. Right, and that's a huge modification to do something like widening a doorway. Ordinarily, that would be something that the tenant would pay for. That'd be a reasonable modification, but the tenant would bear the cost. I'll be honest, I don't know with subsidized housing. I assume that that would not be a reasonable thing to ask someone who's already living in subsidized housing to do. But did you have a?
Under housing work.
Mm-hmm. That the lamp? Okay.
If getting funds from HUD, then HUD
Okay.
pays for the modifications.
Yeah.
For that modification.
Yeah, and that would make sense.
Private individual, then
Yeah. Yeah, and that makes sense. That if you're taking HUD money, that you can use that to make the structure affordable, and that the tenant wouldn't have to be the one to do that. But there's a lot of HUD regulations around subsidized housing that I think people in this room probably know a little better than I do, like Phil. Do you want to? Sorry, just.
I could address that.
Yeah, he would probably know this better.
So Columbia Housing Authority receives funds from HUD, capital funds plus operating subsidies. So since we receive capital funds to make renovations, significant renovations to our properties, then we would be required to make that whatever change to that property in order to accommodate that disability. Now, for the most part, what we will do is we have a transfer list, and we'll put that person into a different unit that is accessible. And if we have someone that's in an accessible unit that doesn't need those accessibility features, then we'll transfer them to another unit. We're required to have at least 5% of our units fully accessible. So we have 719 units, and in the past we had all our 719 units were under basically one big umbrella. So the 200 fully accessible units at Paquin Towers more than covered the 5%. Now we're in the process of renovating all our properties, and so then each property is considered separately as its own like development or own apartment complex. So as we go along, say our renovations up on our Stuart Parker apartments, which is 84 units up there, we're making 16 of those units fully accessible that were not accessible before. We're doing the same out at Bear Creek. We're meeting at least the minimum and doing everything we can to make as many units as accessible as possible. But we'll also come in and make modifications that not necessarily making the unit fully accessible, but will make modifications to meet whatever accessible thing that person requirements there is requires. So if they need some kind of adaptation to their shower, then we'll do that, or some adaptation to their kitchen, removing cabinets so they can get under or whatever. We will do that, and we bear the cost of that. We cannot force a Section 8 landlord to do that. So it's a housing choice voucher program. And so when people get a voucher, then they go out and they choose housing based on their particular needs. And so if you need accessible housing, you need to go out and choose accessible housing. So you can't necessarily go choose inaccessible housing and then force your landlord to come in and make that unit accessible. So, but we do know there's a severe lack of accessible housing out there in our general rental market rate rental stock. So that's where the whole idea of universal design moving forward in multifamily has been, is saying, look, accessibility is not just about persons with disabilities. It's about everybody. It's about a mom with a stroller. It's about an elderly person to make it easier. So one of the things we're also doing in our renovation projects is we're trying to make as many accessible routes, and they call it visitable. That means while the unit itself is not fully ADA accessible, if you have a friend who has a disability, they would be able to come over and visit you and be able to make it through the front door. We've eliminating steps so they can get up to your front door, eliminating thresholds, doing all those types of things to make as many units visitable as possible. Now, obviously, we have some restrictions. There's some things we just can't fix. There's not enough money to fix some of those things. But that's where the Housing Authority stands on those issues.
Oh, thank you, that is.
I had questions. One of them was in lending, leasing, and so forth, the Act applies. One would be under which of the Act provisions would basically insurance, whether it's mortgage insurance of various kinds or property liability and so forth fall, because I think those are probably in that. And the second thing has to do, you mentioned in the affirmatively furthering fair housing, the data things. Could you tell us a little bit about one or two of those things that might be much more useful? Because if I understand the data stuff, that's saying, here's the kind of data that probably would support a disparate impact kind of arrangement. Maybe not, but say just a little bit more about what those kind of data things are allowed. I assume that regulation kind of says if you develop this kind of data, we're saying that that can be used in various kind of cases. Thank you.
So, sure, and those are both good questions. I'll start with the second one first. So what HUD, what the regulation does is it actually makes, it provides tools to the, recipients of the federal money to use. It's incredibly sort of high-level number crunching, detailed statistics about kind of everything you could imagine that might be relevant in making determinations about where community development money should be put, where affordable housing can be put, kind of where needs are. So it's really more of a tool that's been made available for the municipal entities to use. The expectation, of course, is that they should use it. And the reporting requirements. Cities usually have to go through, or any entity receiving the money has to go through an analysis where they identify impediments to fair and integrated housing, and they have to go through and say, we've identified any problems that exist that we're having, here's ways that we might try to fix it. Basically, the HUD regulation now makes that process more rigorous. Cities have to have to actually use data. The data is made available to them, and then they have to actually analyze the data and do a more thoughtful approach. For a while, there really wasn't much thought behind it. It was just kind of another box that got checked. And the regulation now says we want you to be, even though there's a lot of cumbersome things that come with taking any federal money, we want this to be something that's more detailed and thoughtful. So I don't think the idea is really that the data that's being provided is going to then just be turned around and made fodder for a disparate impact case. It's more if you look at this data, you can use it as a tool to make sure you're not having a disparate impact, when you otherwise might be doing that if you weren't paying attention. So it is actually data that's made available by HUD. And these data, I'm not a data person, but there's portals and kind of micro level statistics now that are available. It is true that in a disparate impact case, those are also data driven as well. And so, you'll be looking at demographic data and things like that to make a case like that. But I think the idea behind this was if these cases are going to be cognizable, we should at least make sure that cities have the tools to head off any of those problems before they start, to not kind of commit this kind of offense if they can be helped with data. The first question about insurance. So insurance can also be something under the Fair Housing Act that is considered, if you can't get insurance, you can't get a house, right? You've got to have, the house has to be insured in order for you to get a mortgage. And so denial of insurance or discriminatory terms and conditions in insurance are considered aspects of fair housing. So you can be, I'm sorry? Right, either outright denial would be A, or terms and conditions would be B. And now there's some subtleties there because obviously there's underwriting guidelines and the whole notion of disparate impact gets kind of clouded when you talk about underwriting and insurance because the whole point is that those are decisions that affect different groups based on characteristics and things. So the law is trickier there, but it does apply. And I didn't even mention the fair lending laws. The Equal Credit Opportunity Act is probably the biggest one that specifically has to do with mortgage lending. It prohibits discrimination in lending, and it also prohibits predatory lending when those things are based on protected characteristics. So that's sort of its whole own other thing. That could be another hour. But that also applies in the housing context and has gotten more significance, say, since 2008, when we had kind of the mortgage crisis.
Hi, Professor. I have a question in regards to discriminatory statements. I know you talked about that a little earlier. Can you give us a few examples of what would be considered a discriminatory statement? Would it be something more like, I will not rent to X, or is it them giving an opinion about, I don't like X? So for instance, if a landlord says, well, I don't like to rent to X category because they damage apartments, is that the same type of discriminatory statement as to I won't rent to them? Like what's some good examples?
Yes. Okay, and that's a very good question. Is I teach an entire class period on the meaning of those phrases, but what it basically means is any statement that indicates sort of a preference or a limitation. So that's pretty broad. The way it's phrased and the way it operates, I mean, it's pretty much got to be a statement made by a housing provider or somebody who's in a position to control access to the housing. It's not just sort of some random person on the street saying it. It's got to be somebody who's connected to the housing. But it can be just about anything that indicates that a particular group isn't welcome. Mostly it's geared towards things like advertisements, making sure that people aren't advertising in such a way. There's been some really interesting case law about that where, if you advertise something like, quiet apartments for mature people, you might as well be saying no children, but you're not, coming out and saying that. So there's been advertisements about things, or cases about, coded messages and things like that. There have even been some cases where the courts have allowed to go forward when there's been sort of long, consistent advertising done by sort of big housing providers where only white people are in the ads over, weeks and weeks and weeks, and the only, African Americans that are shown are like a doorman or something. And so that's actually been found to transmit a message that, this is the group we want and that's the group we don't want. So it actually gets pretty broad application. It's usually used A lot of times it can also be used in conjunction with other sections of the statute. So, I mean, a lot of times if you get someone who's discriminating, they're also probably at some point saying that to somebody that that's what they're doing. So a lot of times they're not standalone complaints anymore, but it gets added in. Most people who advertise now, like I said, sort of institutional landlords or housing providers know that they can't say some of these things. So a lot of times, recent cases about ads have to do more with sort of individual people who say, I've got some units, I want to go on Craigslist. So maybe people who aren't as well versed in the law. So that's where we've actually seen some more interesting recent cases have been about, what if you go online and say, I've got some apartments, I only want to rent them to women or whatever. So that's been it kind of came back after not really being something that you saw much with ads. And even in sort of cases that I've had, I'm trying to think, when we would have someone discriminating or harassing, kind of engaging in racial harassment or national origin harassment, a lot of times that harassment had a verbal component where, the landlord would be, saying things like, I hate Mexicans, or, and so that would be a pretty clear 3604C violation as well. So they really kind of run a gamut. Right. It's a good question.
Hi, I sat on the Governor Stern Committee for Reentry, and my question to you is, well, we found that in the top 5 barriers for these ex-offenders to reassimilate successfully in society, either 1 or 2 is housing. And my question to you is, we have found, not necessarily in Columbia, but around the state, that the housing authorities had rules and regulation where they wouldn't accept ex-offenders into the housing. Is there anything under the Fair Housing Act that can be used to help with this situation?
So, and again, there's kind of two. So in general, the Fair Housing Act, with the disparate impact claims being cognizable, would say, in general, if a landlord is having kind of a blanket rule, we won't even consider anybody for tenancy if they've got any kind of criminal record. That's going to have a disparate impact. And it would be probably hard to justify. I mean, the justifications for a rule like that would be, safety, things like that, making sure that the apartments are going to be kept in good condition and things like that. So you may not want kind of, certain recent violent offenders to be occupying multifamily housing. But that is not that is not served by a blanket kind of before you even get your application through the door ban. And so it would, and I'm kind of making arguments now that I think the courts would entertain. In light of disparate impact theory, a landlord would have to kind of justify why they had a particular rule. They could still have one as long as they had a good justification. So if your rule is being applied, so that someone with a bad check case 25 years ago can't get tenancy, that's probably not going to serve the stated goals of safety. And so it might make landlords be more thoughtful about kind of when they consider criminal history and what sorts of criminal history and things like that. As far as sort of with subsidized housing, there's kind of a whole set of rules around that are different, as I'm sure you know. And I'll be honest, I don't know now, in light of all of this, what HUD's approach is. I don't know if Phil might know, or if you can speak to that. Yeah, because it's its own universe of regulatory.
So back in, it was April of 2016, so about a year ago, HUD came out with some new guidelines discussing criminal background. And what they basically said is that it has a racial, disparate impact. And the guidelines indicate that you cannot use the fact that someone's got a conviction as an automatic denial. So landlords that have, if you've got a conviction, I will not rent to you, automatically is going to be discriminatory upon disparate impact. And then it's going to start going through that whole longer process that we didn't really go into, but it will end up meeting that standard. So what that indicates is that if somebody has a criminal background, they can ask, but they cannot automatically deny. They then have to say, all right, come in, explain this to me, what's going on. and the guidelines indicate that it has to be an individualized assessment. And it seems to be, for private landlords, it's across the board. So even if someone's been convicted of murder, they cannot automatically deny. It also indicates that someone's a sex offender. They cannot automatically deny. They have to bring them in and do an individual assessment. They can then be denied at that point, but it cannot just be a blanket ban. And then there's a little bit different rules that apply to, federally subsidized housing. There's a couple things that they can be denied for. Manufacturing methamphetamine, I believe, is one of them, and sex offender, I think, is another in some instances. But there wasn't a law change. It was just a different interpretation given by HUD. So theoretically, this could change at any given moment.
Right. Yeah, and again, so for subsidized housing, I know there's some different considerations, and I know even for, different types of subsidized housing, I know there's HUD will sometimes have different requirements, and I honestly don't know how those have changed in light of the changes in the law. Obviously, there's certain, HUD operates under some different rules when it is the housing provider, and so I hesitate to say what they're doing now with respect to that, because I'm just not sure. It's changed so much. But it is true, and I don't know if Phil has a thought on that he can come share with us. How, if HUD's got some specific things for that, or sorry. Oh, yeah. Yes.
Great.
Yes.
Good morning. I'm Phil Steinhaus. I'm CEO of the Columbia Housing Authority. Mike, my interpretation of that regulation is a little bit different than yours, so I'm going to have to go back and read it more closely. My interpretation was essentially that solely in a report of an arrest record could not be enough to deny or terminate someone's assistance in housing assistance. However, I don't believe it said anything about you could not deny someone for a previous conviction.
You can deny, but you have to do it as an individualized assessment, so you cannot
Okay.
have a blanket list.
So our policy requires that anybody's application that gets denied has the opportunity to request a review, and we do that individual assessment during that review. And that at that time, that's when that person can come forward and explain to us whatever circumstances were involved in their previous arrest or conviction, and why those circumstances have changed, and why they would not be a threat to other residents living in subsidized housing based on their past behavior. And I want to make it clear to folks, one of the things we really struggle with here is, in particular in Paquin and Oak Towers, but mostly in Paquin, we have a lot of clients that are working with agencies throughout our community that have various mental health issues. They have mental health issues that are also dual diagnosis with underlying substance abuse issues. And so these agencies have helped these folks get off the street, help stabilize them, help get them off of their past substance abuse, get them on proper medication, into therapy, treatment, et cetera. Tons and tons of resources have gone into helping these people become stable and live as independently as possible. Now, if I put somebody in there who's not achieved sobriety and is still using, or still, if somebody wants to use in Paquin Towers, if they want to use by themselves, we will never catch them. But guess what? Nobody wants to use by themselves. They want to go knock on their neighbor's door and say, hey. And I've seen where we've introduced someone where we gave them a second chance when they said they were all clean. And what happened? They ended up taking 5 or 6 other residents down with them, and then they were back through that revolving door of treatment and agencies and tons of resources. It was hard on them. It was hard on the agencies. And so that's why we have very strict policies to protect the people that are living in public housing now. So, and to speak to Lorenzo's issue, where you are there, if someone comes to us with a prior prison record, and then they say, Lorenzo comes in with them, and they come in and say, look, when I was in prison, I got my GED, I did this, I've got a support system when I get out, I got people that are vouching for me, here's all the things I've done to show that things are gonna be better now that I get out. That person we're gonna welcome in. And we're going to stay connected with their network of support services. So if we see something going on, that's when we're going to reach out and say, hey, can you help us? So, but low-income families deserve to live in safe neighborhoods, and I think Mike spoke to it earlier in his comments. And any of you that have lived in Columbia for a long time know that Housing Authority has been transformed. We want to be an agency that helps break the cycle of poverty. I cannot build enough housing to warehouse all the people in poverty here in Columbia. So the only thing we can do to cut down our waiting list and reduce the demand for affordable housing is help people that are in there now move up and out of poverty. And I can't do that if everybody around them is causing drama, committing crime, engaged in criminal activity, et cetera. So our residents want safe neighborhoods, and so that's why we have those policies.
Thank you. That is,
I think we have time for one more.
okay, all right.
Hi, I'm Lisa Turner. I'm with Mo Housing. I wondered, you mentioned earlier about a lot of cities will have ordinances that govern density of group homes and that sort of thing. And that's an issue that we're working with statewide. And I know that Columbia has recently made some changes to an ordinance that they had. I wondered if you could speak to that and provide some information if you're aware of that. Thank you.
So, in general, the rules surrounding group homes have actually recently been clarified. DOJ and HUD issued a joint statement. It wasn't anything new. It was more their saying this is our understanding of the law and how it should operate. And some of the characteristics of the law were such that you shouldn't have just one area of town where all the group homes get permitted for. Those should be spread out. You shouldn't kind of ghettoize them into one area and say that's where the group homes are. They should be kind of integrated through the community. There shouldn't be kind of more onerous requirements for them than there would be for any other kind of group living situation. Basic things like that the law, probably already required, but HUD and DOJ wanted to just make clear. Needed to be the case that sort of denials of permits shouldn't be done based on stereotyping or irrational fears, things like that. I actually will say I don't know what Columbia has most recently done, and so maybe somebody who's been more directly involved in that could speak to it, but sure. I guess you'd say who you are, too.
Yeah, my name's Adam Cruz. I'm the ADA coordinator for the city and assistant city councilor. And I staff the Disabilities Commission, who took up the issue of group homes. So the City of Columbia had an ordinance that required all group homes to be at least 1,000 feet away from other group homes. And the goal of this ordinance was, like you said, we wanted an integrated community. We didn't want a group home portion of Columbia. We wanted them spread out all across Columbia. The problem, though, and as HUD stated in the guidance, is they want an individualized assessment. They don't want the hard 1,000-foot rule because you could be 850 feet away and that could be entirely reasonable. So Columbia's changed the group home zoning ordinance from a 1,000-foot hard rule to more of an individualized assessment.
That makes perfect sense. Okay, well, I think I'm out of time, but I want to thank you all for having me and thank the city again. So.
Thank you, Professor Oliveri. Just a quick note, if you do come up to ask a question, please be sure to speak into the microphone as we are recording this. Our next speaker is Amanda Biondolino. Amanda Biondolino is a member of Smith Amundsen LLC, a law firm in St. Louis. As a member of Smith Amundsen's commercial litigation practice group, Amanda provides clients with advice and counsel on a wide range of business matters. Her goal is to help her clients grow and protect their business. Her experience includes insurance defense on a variety of matters, including employment and housing discrimination, wrongful termination, trademark infringement, and healthcare liability, among other issues affecting business owners. Amanda previously worked as a human rights attorney for the Missouri Commission on Human Rights, where she provided legal analysis and advice on discrimination matters and litigated claims of housing and employment discrimination. Let's welcome Amanda Biondolino. Thank you.
Okay, I'm going to bring it from that very broad overview of fair housing to a pretty narrow topic but what I think is usually a pretty entertaining and interesting topic with the stories that come up in this area. It's a very important area and one that's becoming more and more prevalent as individuals with disabilities, particularly people with mental disabilities, are getting their housing integrated into the community versus being kept in an institution or I don't want to say a group home setting because those are more community-based anyway, but more an institutional setting. They want housing with everybody else, and they should be able to get that housing and whatever accommodations they might need as long as they're within the bounds of the Fair Housing Act. So this is my name, Biondolino. That's correct. That's how you say it. As was told during the introduction, I spent a few years working with the Missouri Commission on Human Rights, working primarily in fair housing. Now I've shifted and I spend the bulk of my time helping businesses operate their businesses successfully within the bounds of the law. I fight their battles when those battles come up, but certainly what's best for everybody is for everybody to understand their rights and obligations and operate, it's fine, within the bounds of the law and do what they're supposed to be doing. This is the second most important slide that I put up here, which is just, a legal disclaimer. It's good that everybody's here getting this information, but every instance is different, and every situation with these discrimination complaints or concerns are going to turn on their own facts. So individuals are kind of lucky because if you have a question or concern, you have the Commission on Human Rights on a state level. You have HUD, who will investigate complaints for you. If you have a question or concern, you call those offices. You have a great city here that also will take your complaint and on a local level can address your complaints pretty quickly and concerns. So individuals have those options. Businesses, I don't know how many landlords, housing providers we have in the crowd. You want to get your counsel involved and be very careful if a complaint comes up because it involves legal liability, which is money at the end of the day, and you want to make sure that you address it and do the right thing in any instance, and they're all very different. So I'm going to not going to go into the fair housing law. We've already talked about that. With the service and support animals, it's a reasonable accommodation issue. So off the bat, when it's a reasonable accommodation issue, right then and there, it's a gray area. There are no lines in the sand. It's very difficult to make generalizations. You want to look at each instance individually. And we're going to talk about service and support animals and practice tips for everybody. And I'll leave time for questions. I'm standing between you and snacks, so I will not make us go past 11:15, that's for sure. This is the most important slide, very general. If you are a housing provider or a tenant, and you have a housing issue, a disability-related housing issue, whether it's service animal, whether it's the ramp, the parking space, whatever it is, as we're all getting our self-help on Google, which is great because there's a lot of information there, make sure if it's a housing matter, you don't just hit on a great ADA website and think you got it made, this fits exactly with what's going on with you. You want your housing provider to do that. The ADA, as Rigel said, was passed after the Fair Housing Act, and it doesn't cover housing. All the disability protections are in the Fair Housing Act if it's a housing issue. So as you're Googling, there's good information out there. I would recommend making sure you're looking at a HUD site or a HUD document. You have my handout at the end of the presentation. There's a couple websites, and if you even just Google, HUD, reasonable accommodation, HUD, service animals, you will get some good memos that were put out by HUD and the Department of Justice. All good information, all very easy to read. Make sure that if it's a housing issue, you're looking at housing materials. There's a good criminal history memo that people have mentioned. It's easy to read. It's out there. You can find it. And it's a good place to start. I think the Fair Housing Act is much more permissible than the ADA. There's one little caveat, which we'll get into, where the ADA is pretty individual friendly, but the Fair Housing Act is pretty permissive. I mean, it's people's homes, it's people's sanctuary. You can have a miserable day at work, your kids are having trouble fitting in at school. Where do they come home? They come home. Like, they get away from that, they get to come to their sanctuary at home. It's important that people feel safe and secure and have good quality housing. So it's going to be much more permissive to those individuals living in the housing when it comes to these reasonable accommodation and modification issues. We've talked about this, know your locale. You do have some extra protected categories in your city here. Other cities, if you've come from surrounding areas, they may have individual ordinances as well that get more permissive. It covers, and we talked about this, any type of housing. If it's a dwelling, people return there, it's going to be covered. So, of course, houses, mobile homes, sure. But what about the shelter? Well, it's going to depend. Maybe that is housing. If they come there every night, they have their same space, their same bed, they have their belongings there, then it starts becoming housing. So you got to, if you're a shelter provider, you've got to be very careful about where you fall on this and get some good advice, because you may have to provide your tenants with more accommodations than what you would if you're just a one night, nobody gets to stay, it's very transient, temporary shelter. So something to think about. Also, anybody who has a hand in these decisions can get named individually and have individual liability. So I always put that out there, because that means if you tell somebody no, they can't have that animal, your name is getting listed in that complaint, and if they go to court and get $1 million judgment, get out your checkbook, you're on that hook individually. So be very careful about what you do and how you educate yourself, and you educate your employees so that they know what they're supposed to be doing. These are all the protected categories. We went over all of that. Went over all of this, see? Now, Rigel touched on this. So individuals who are protected under the disability section of the law has to meet this definition, okay? They have to have a physical or mental impairment that substantially limits one or more major life activities. It's pretty broad, like seeing, walking, working, things like that. It's going to be interpreted broadly, but this is the definition. It's not someone gets Social Security benefits, someone has a medical diagnosis from the doctor. That's good evidence, but this is the definition that they have to meet. So if someone doesn't have a diagnosis, or they don't have a license plate, hang tag, a handicap license plate or a hang tag, that doesn't mean that they're not disabled and protected under this law. If they have a physical or mental impairment that substantially limits them, they can meet this definition. It's going to be interpreted broadly. If they have a record of an impairment, they're really not impaired. They have some kind of record in the past. They can still be protected, and regarded as is a big one. That is, I do not have an impairment, but someone regards me as that. I sign up for the shuttle to go to the clinic. Okay, maybe it's a routine examination I'm getting, but my housing provider thinks I'm going for HIV treatment, something like that. My mail comes and it gets misdelivered. Someone sees that I got a bill from such and such doctor, and they think, oh, he typically treats, that's the place where drug addicts go get help. That's, people have their perceptions of what certain agencies do for people. Oh, this person's getting a visit from such and such caseworker. They must have some kind of mental disability. May not be true at all, but if that housing provider starts making decisions based on those false assumptions, that individual is protected under the law, even though they're absolutely not disabled in any way. So something to think about. Now, if you meet that definition of disability, you're of course entitled to equal treatment, but you're also entitled to reasonable accommodations and modifications. Accommodations are changes in rules, okay? So someone needs to pay their rent late because their Social Security check comes on the 10th and not the 1st. You charge a late fee on the 5th. You're gonna, if they ask you for that change, you're gonna need to accommodate them. They have a disability-related need to pay their rent a little bit later and avoid that late fee. So think of that like rules. Modifications are those structural changes, typically cost money. I want the ramp put in. I want a wider door that we've talked about. Those cost money. Typically, a tenant's going to have to pay for those. There are some caveats, but typically with private housing providers, that individual is going to have to come up with that money to make that change. The housing provider has to allow it. So you must make the request, okay? An individual, the housing provider isn't, telepathic. The person has to make the request and say that they need the parking space or whatnot and ask for that accommodation. Doesn't have to be in writing, doesn't have to use a specific form. If you have a specific form, that can be helpful, but if the individual doesn't use it, that's not a basis to say they never filled out the form, so that's why they don't get the parking space. If they've told you they need the space because of physical impairment, then they've made you aware of it, and that's the only type of request they need to make. No magic words. They don't even have to say reasonable accommodation. They just need to say enough to put you on notice that they need something done for them because of a disability. And so as a housing provider, you need to make sure if somebody's making some complaints about things that are kind of difficult or hard for them, that should trigger something like, what are you asking me for? What are you saying? You can ask for a little bit more information from them. Do not go into their health information. What is your diagnosis, your disability? Do not ask those personal information, but you can say, are you asking for anything? Do you need something from me? You can ask those probing questions and find out what's going on. But there is no specific language that has to be used or that someone can rely on to say, well, they didn't ask for a reasonable accommodation, so how was I supposed to know? You're going to be held to be aware and then start engaging in some kind of interactive process with them. Now, they ask for it and they meet the definition of disability and their modification or accommodation is necessary, and the two are connected, whatever they're asking for, kind of those three conditions, then they're pretty much going to get it. Okay, so they have to have a disability. The disability has to be the request they're making has to be necessary, and the two have to be related. So I have a physical impairment. I'm in a wheelchair. I want a close parking space because of my physical impairment. That's as simple as it is. Okay, if I am in a wheelchair, but I want to have an emotional support dog, those two aren't related. Okay, if you need that emotional support animal, you need to have a disability-related need for it. Would be some kind of mental or emotional disability issue, and we'll talk about that. But you see how it has to be related and it has to be necessary. It has to be necessary. It can't be, well, it'd be great if I had this. That'd be nice. Well, that's not enough. You're not really communicating that it's necessary. It needs to be necessary for someone to have that accommodation in order for it to be required under the law. So with service and support animals, the ADA, which covers places of public accommodations, where it's relevant to these service animals, and the Fair Housing Act, they're different on what specifically comes into play and what people have to do to be allowed the animal. Okay, generally the ADA is it's much more restricted. So this is the law that protects people with disabilities in places of public accommodations, like going to the grocery store or the bank, right? So it has to be a dog, or it could be a miniature horse, believe it or not. They must be useful, and I think they live a long time. So there is a miniature horse exception, but a dog. So, and it has to be trained to do something. So those are two important things. It has to be a dog, and it has to be trained to do something for this person. A business owner can ask, do you have a disability? And what does the animal do for you? And that is it. So Do not get yourself in trouble asking any more information than that. Not what is your disability? You don't get to know their diagnosis. It's, do you have a disability, yes or no? What is the animal trained to do for you? The animal fetches, the animal guides me, the animal alerts if I'm going to have a panic attack or an insulin attack, something. Boy, that's it. That's as much information as you're gonna get, and they're good. They're going as anywhere anyone else can go. They're going to the grocery store. They're going in the restaurant. It's not the dog is a health hazard and can't go there. If a person without a disability can walk through these aisles, then so can that person and their service animal. Doesn't get to go back to where the guy's butchering the beef in the back, but then neither can I. So that's not an issue. Doesn't get to go to the back of the house at the restaurant, but then neither can I. So the dog can go in the dining room area, dog can go in the bathroom, not a problem. And businesses don't get to know how that dog was trained. They don't get to see the card. They don't have to have the neckerchief on, you know, they don't have to have the vest. All those are great things. If people have it, it's generally helpful, but certainly not required. And not having, your city can issue tags, but when it comes to the Federal Fair Housing Act, there's not that requirement that there's any marking on there. So you gotta be very careful if someone's gonna see you under this law. You can only ask, you know, do you have a disability? What does the animal do? It helps them do whatever they say. You have to take it at face value. You don't get to ask for any kind of documentation. And that's because, you know, when I go to the grocery store or I go to the bank, I don't have to have any kind of documentation saying where I can and cannot go. We're not going to expect an individual with a disability to come up with that documentation every time they go out. It's just a policy decision that was made, and it's really not going to change. So your staff should know what they can ask, and they should know that they shouldn't ask any more. We'll get into what's reasonable or not with these animals. Certainly, if someone's, you know, going to the grocery store with, you know, the vicious pit bull and it's lunging at everybody and it's very scary, okay, that's not very reasonable, right? But it's not anything to do with these two questions. And it's also, you want to make sure it's not a strict ban. You've heard a lot of talk about individualized assessments and the blanket rules, like with the $1,000 limit. Even if those have a basis, you know, with good intentions, which is we want them to be spread throughout the community. It came from a good place, but it's that hard and fast rule that gets people into trouble under the fair housing laws. So the animals have to behave, the person has to control the animal. If those things aren't happening, then that's what you want to take note of. The dog was lunging, the dog was growling, not, it just, they didn't really, I don't think they really needed that dog. That's what you see a lot is, I didn't think that person really needed that dog, so that's why I said no. They seemed perfectly fine to me. That's gonna get you in trouble every single time. So this is where I say the ADA is much more permissive to the individual because you only get those two questions. They're basically yes or no answers, very little information, and that's it. Under the Fair Housing Act, it can be any animal, okay? It's not just a dog. It can be any animal. It can be a snake, it can be a tarantula. Whatever provides, you know, comfort to this individual, that could be it. It might be that someone, I mean, I don't have a tarantula, but I know people who have them at, you know, their office. It could be that that's all that person can handle, but having that thing to care for helps them with whatever mental or emotional disability they're dealing with. So it can be any animal. It doesn't need to have any training. So an emotional support animal, just by its existence, can help someone. Doesn't have to be trained to do a single thing. Housing providers should not be charging rent or deposit for a service animal. Okay, you can charge all the rent and deposits for pets that you want, and you can have a million rules about the pets. That's fine. But when someone has a service animal, you cannot charge them that deposit, and you cannot charge them that rent, so don't do that. You are protected, of course, If there's any damage caused by that animal, you can get that back when the person moves out, just like as long as you know all the tenants who you rent to get charged for the damage to their property, which most do. If this person has a dog and there's additional damage, then you get to recoup that on the back end. But you can't put that additional barrier in front of someone with a disability by saying you have to pay extra because of your disability. Like I said, like with before, the animal can go anywhere the individual can go. The animal gets to sit by the pool, okay? I don't think the animal gets to go in the pool, but the animal gets to sit by the pool, and the animal gets to go to the laundry room. The animal gets to sit in the gazebo. Okay, the animal gets to go anywhere, just like when you're going to a business. The animal can go anywhere where people can go. And another thing that people sometimes face is saying you have to have some kind of liability insurance because of your animal. You cannot ask an individual to have liability insurance. The housing providers have to take on that as the cost of doing business providing housing. So couple things with insurance. There are insurance providers that say, I will not cover dogs, or I will not cover pit bulls, or whatnot. But be very careful relying on that, because typically those insurance providers know they have to comply with fair housing law, and they have an exception if it's a service animal. If not, they certainly should be giving it to you. And if not, then they're in violation of the law, and you might want to complain about how you're not getting the full benefit of your protections under the law, because you have just as much protection as anyone else in that instance. So the housing provider is responsible for any extra insurance that is needed. The individual can't be forced to take on that cost. I just put this on here. It doesn't matter what someone calls the animal. It's a protected accommodation. It doesn't have to be a service animal. When it comes to housing, it can be an emotional support animal, companion animal. There's lots of different people who call them different things. Like I said, there are no magic words, so don't get yourself in trouble relying on some kind of terminology. If the animal's needed because of a disability, then it's necessary and it's going to be covered. So, talked about how businesses can't really ask for any documentation. They can only ask those limited questions. Housing providers can ask for more depending on the apparent nature of the disability, okay? If someone comes to you and they're blind or they're in a wheelchair, you are going to be hard-pressed to ask for medical documentation that they need the accommodation they're requesting, as long as it's related to their obvious disability. You know, don't ask someone who's in a wheelchair to give you some medical documentation that they need a ramp. It's obvious. But when it comes to typically mental disabilities or those non-obvious, seizure disorders, things like that that aren't obvious, housing providers can ask for additional documentation. There's no specific requirement for what it has to be. So it doesn't have to be a doctor's note. Doctor's note, I always say that's pretty golden. You're not going to sit in judgment and second guess someone's treating physician on if they're disabled and they need this particular accommodation. It's going to be nearly impossible for you to overcome that medical provider's authoritative decision on the matter. But it doesn't have to be a doctor. Social workers, sure. I don't know, what about a teacher? There's no hard and fast rules. Once you start getting away from the more authoritative, it's not reasonable. You need someone with, it needs to be reliable documentation from someone with authority to know. So what does someone's teacher have authority to know about their medical condition? That's where it starts getting tenuous. Medical provider certainly has authority to know what this person needs. That's why on the spectrum, that's pretty golden. And all it needs to say is that this person has a disability and they need this animal because of the disability. Again, a pretty limited disclosure of information. You don't get to know their diagnosis. You don't get to call them up and verify. Do not ever call someone's treating physician or verify any of this. If someone gives you a note that you can't really decipher, it's chicken scratch, you don't really know, go to them and say, we comply with the fair housing law, but I need some legible, reliable documentation for your file so that we can move forward with this. You can ask for that. I've seen some pretty illegible notes on pads of paper. That's not very reliable, but something on a letterhead from a doctor, that's pretty good, and it's going to be hard to overcome that. Then what are the issues that come up? Multiple animals. How many animals does someone need? Do they need 5 dogs or 10 cats? Well, and you can't have a rule. So it's not, do not ever make a rule that says, 1 dog and that's it, or 2 dogs and that is it. Because you're going to run into problems with that rule. Why? Because, court, they don't like the rules. What if you have, first of all, I could probably have 3 to 5 dogs in an apartment, and I'd be fine. I could take care of them. There would be no issue. So why, if I needed those because of my disability, would be denied? It's no problem in that unit. What about the difference between having animals in an apartment versus a home out in the community, or a home in a suburban setting or a very rural setting? You could probably have a lot more animals. So hard and fast rules aren't good. You want to look at the individual case and decide what is reasonable in that instance. Depending on the type of housing and the situation involved, that could take many different forms. But each animal, there needs to be a disability-related need for each animal, okay? So they're going to have to get a note that says they need 5 dogs. They do need something that says they need all of these animals. Or else it's not reasonable. Or, this one is their support animal, and then that one is the pet. That comes up to if this one provides some kind of disability-related need, but they also have a pet. You can limit the number of pets. Again, I can't say that enough. That's fine. But, this one is then going to be an exception to the rule. Also, the accommodation is for the person. So if their dog, their service animal, needs a friend because they go to work or whatnot, the animal doesn't want to be home alone, that might get into some issues on is the dog really needed. But I've seen it where so-and-so, I need 2 dogs. I got this note for 1, but I need 2 because my dog, I don't feel bad when my dog is alone or it needs a companion or whatnot. That's just not protected under the law. That dog doesn't get an accommodation. But that individual has to get documentation that they specifically need all those animals. The type of animal, this comes up a lot. And I mean, I'll be honest, it's easy to go to the shelter and adopt a dog. It's probably gonna be a pit bull mix. Like, that's just what they have. So, I have sympathy in that regard. If someone of limited means needed a dog, they're not gonna be able to go get that designer Pomeranian for $500 or $700. They go to the shelter, there's a lot of pit bull mixes there. Yet a lot of cities have pit bull bans. A lot of housing providers have these bans, and it could be all kinds of breeds. The, Dobermans and the, I can't think of, what's that big black and brown dog? The what? Rottweilers. And so that's fine to have those for the pets, but the individual, if they need that and they get that documentation, they need this dog as a service animal, you can't blanket exclude it. That dog has to be individually judged and assessed. What are some other issues? We talked about the accommodations for the animal, not the person, or it has to be for the person. Those are typically what I've seen with issues that have come up with animal requests. People get reasonable accommodations. An accommodation isn't reasonable and someone isn't entitled to it. These are the defenses or the exceptions. An undue financial or administrative burden, a fundamental alteration of the program, or a direct threat. Now, I'm just going to say a fundamental alteration of the program does not mean we don't allow dogs and they want us to fundamentally alter our housing. So people think that because if you're just a regular person reading that, that would make logical sense to you. But that's not going to hold up under the law because the law is going to say, no, you should have given them a reasonable accommodation from that rule. So it has to be something more than that. I can't think of a good animal one because in that regard it's pretty simple. But say I'm in a wheelchair and I call up my housing provider and I say, I want you to shuttle me to the grocery store because I can't get there now. They don't provide that service. That'd be a fundamental alteration in what the services they provide. They don't have to, that's not reasonable. But what if they do provide a shuttle service once a week and then I have a disability-related need for a certain van or something? Well, then providing the shuttle back and forth isn't a fundamental alteration in what they do. They do that. So now they have to look at, can they accommodate me? Well, it may be very expensive for them to accommodate me. It may not be. I don't know. You better look into it before you just say, well, that cost a fortune for me to get that van. That might be the case, but you're going to want to look into it. You also want to reach out and see, are there other ride services that are free? I would say that every part of the state has a Center for Independent Living, and I'm sure Columbia has one. I would call them if you ever have any kind of request for a service, and that would be the first place I would go. Call them and ask them what they know. They know, believe me, they know all of the good deals in town when it comes to these services, and they can help you arrange that. But to just blanket say, I can't do that because I can't get a new van, that's going to be a difficult position to defend if you've done nothing to look into that. And also, then you're going to open up your books, and they're going to want to look and see, well, how reasonable is it? How much money do you make? So be very careful about relying on an undue financial burden defense. There's some issues with that. The biggie is this direct threat defense, and that's because when you get into these big dogs, another one I didn't mention was size, people putting weight limits. You can have a 35-pound dog or 25-pound dog. Fine to do it with pets, but when it comes to a service animal, you want to assess the animal. It might be reasonable to have a smaller dog in an apartment, but a house, or depending on the square footage or amenities, it could be accommodated with a larger animal. But if the animal's a direct threat, then it's no longer reasonable. So it has to be, like I said, based on an individualized assessment, so make sure you're doing that and not just the blanket bans. And it needs to be objective evidence. So it can't be that you're afraid of pit bulls. Like, I'm the landlord, I'm afraid of that dog. It has to be something objective. The dog is lunging. The dog is, showing its teeth. The dog pulls at the leash and that person, hardly can control it. Those are objective things that you've seen that show this dog is unreasonable, other than just subjective, I'm afraid, or someone else has said they were afraid. There has to be some objective evidence of that. Factors to look at, duration of the risk, nature and severity of the harm. I mean, if the dog is just excited and pulling, the nature of whatever harm it might cause is not the same as if the dog is baring its teeth and growling at somebody. I mean, the potential for that harm is much greater than, a dog, knocking you as it's running around. So you got to look at the nature and severity of the harm, the likelihood that it'll really occur, the imminence of the harm, and can a reasonable accommodation modify the risk? So you do get like an extra chance. If the dog is lunging or behaving poorly, and that person says, let me get it retrained and can get into some kind of a program, fine. If they can show they're taking some reasonable step in a reasonable period of time, fine, you can get one more chance. But if the dog can't be kept in control, then it might not be reasonable to have it in the housing. So I always put tenant responsibilities. They need to control the animal, care and maintenance for the animal and the property. So when you can smell that apartment 10 doors down, that's not reasonable in a multifamily setting. So if there's not a way to accommodate that, to remedy that, then that animal isn't a reasonable accommodation. It's not reasonable for that person to have it there. Now, if the tenant before had a dog that did that, you can't judge the next person based on that. That's what we see a lot. Well, people in the past, their dogs, defecate on the carpet, they ruin the carpet, they get fleas, whatnot. Well, whatever happened in the past is that individual's issue. This individual's getting judged on their circumstances, so you kind of have to start fresh with each individual. But people do have to care and maintain not only the animals, but the property as well. Waste disposal, you know, they have to pick up the dog poop that's throughout the apartment complex. And it's not reasonable to say, well, I can't do it. If someone, you know, really has a physical disability that prevents them from doing it, of course. If someone has, you know, a physical impairment, they can't stop and pick it up right then and there, fine, they get an accommodation, but a caregiver, friend, family, somebody does need to clean up after the animal. It's not going to be reasonable to just say absolutely no. Or maybe your maintenance staff can do it and it's reasonable. It depends. You have to look at every individualized assessment, but certainly just, I can't do it, so I'm just not gonna pick up after the dog isn't a viable option. And then, like I said before, the cost of actual damage, other than normal wear and tear, landlords are entitled to that. Just make sure that you're doing this for all tenants. So if any other person who moves out, you're just done with them and you move on to the next tenant and you don't give them the, you know, you don't deduct from their security deposit, or you didn't require them to take a security deposit, you don't give them a list of damages, you just move forward. Well, if a person with a disability has a service animal coming in, you're going to run into problems if you give them a list, because you're treating them differently than people without a disability. So make sure you're doing that for all of your tenants, and then you can collect it for damage caused by service animals on the back end. For landlords, I always say, and individuals, if you have this issue, familiarize yourself with HUD guidance, because it's pretty good and easy to read. And what that HUD memo talks about in regards to reasonable accommodations and service animals, you know, that's what the commission is going to follow pretty much. That's what the courts, they're going to look at it. You know, HUD is pretty, I think, pretty reasonable in the claims that they've put forward and what it holds up in court. Like that case that Rigel talked about, the disparate impact case that the Supreme Court upheld. I mean, it was pretty much basically HUD's position all along, and it was reasonable. So I think you are good to really look at HUD's guidance and follow that and think, you know, I want my property managers to look at this and understand it. If these types of situations come up, that's basically how you handle them. If you have any questions, seek some guidance. But I certainly wouldn't deny something that is in a readily available HUD memo that's very clear cut in that memo, because you're going to probably run into some difficulty defending that. Like I said, a tenant's physician is pretty good. Do not second guess that. I always say, like, where did you get your medical degree, Mr. Property Manager? This is an actual treating physician who's saying this person needs it. We're not going to get into a battle of experts on this. If it gets to a litigation and we're defending this in court, we very may well, but when you're running your business day to day, you're not going to want to be putting yourself into that kind of legal liability if they've got that doctor's note. Minimal inquiry, no additional fees or rules due to the service animal, and like I said, seek legal guidance if you have any questions or concerns. These are the three, well, I don't have the website listed, but if you Google those search terms, that's where you'd find those memos. They're pretty good information. And so that's really the presentation. Anybody have any questions about? Yeah.
I'm Sandra Herring. I'm an investigator with Missouri Commission on Human Rights. I have a question. I had this brought up recently. The landlord allowed the accommodation with the service animal. But he's saying when she moves out, I have to tear up the carpet, because what if the next tenant has a sensitivity to allergies or something like that? They can't charge that tenant for pulling up that carpet, because that's a choice that they're making to do that, correct?
Well, so here's the thing with this. So this comes up a lot, the allergy defense, right? So I don't want to allow this dog in my properties because I'm allergic, or what if someone else is allergic? Or I've seen it with kind of group home type situations, or group tenants, whatever you want to call it. It's not fair to someone else, because what if they're allergic? And I always say, first of all, if you're premising your denial on a what if, you're getting yourself in trouble, because that's purely speculative and you have no objective evidence that that's even a real issue. So you have no basis for a denial on that. Second of all, you know, if the carpet's damaged, and like I said before, when that person leaves and you do this for all the tenants. You get, if it's above normal wear and tear, they have to pay to bring it up to standard. If you have to replace the carpet, you have to replace the carpet. But if that's what you do for all of your tenants, right? So once you get it up to that standard, then that's it. If the next tenant comes along and they can't, handle this apartment because of some residual dander or something in that unit, then I would say that's the cost of doing business. You need to then, transfer that person somewhere else, or if you replace the carpet, you replace the carpet. But that burden isn't on that individual. Once they move out, they're responsible for their damage. That's where their responsibility ends. While the person's still living there, I'll just throw this out as well. Concerns can be taken care of with proper HVAC filters and ventilation. So if that's really an issue that's going on, the landlord might need to look at that and make sure that they don't have an issue there. That would be reasonable for a landlord to take care of that. But yeah, a lot of that though is speculative, and that's not a good defense for a landlord to take up. It needs to be an actual concrete thing that happened. And even then, it could probably get chalked up to cost of doing business. Yeah.
I'm Nina Balsam, and I work at the Missouri Commission on Human Rights in St. Louis. We had a situation where a woman had what looked like a pit bull, but she swore it was not a pit bull. She swore it was a boxer mastiff mix. Anyway, and she was training it herself. And the city required a number of things if you had a dangerous dog. So insurance was one of those things. So these things are very nuanced. If she's training it herself, does that mean that the dogs had training? How do you pick these things apart?
So that's going to be a very tricky issue because the dog isn't trained to do anything. She's training it. So right there, she's got some issues. Also, I would say, the city, if she had a trained animal, the city should accommodate. Off the bat, can't impose all these rules on her because it would need to accommodate her. If her dog is vicious and dangerous, then it's a direct threat. She doesn't get an accommodation and it falls under the regular law. But if her animal is not a direct threat, she needs it, she's got the documentation, then we would expect that city to give her an accommodation. Now, that trickiness with her is that the dog is in training. So, she's going to be hard-pressed because she doesn't have the trained animal. And I'd be taking the defense, if I was taking that case, that the animal's not a trained service animal and it's not yet protected under the law. So she might file the complaint. She might get some help that way. People might start working together. An accommodation might be to give her some time to get the dog trained. That's pretty reasonable. We try to make it an interactive process, and it's not just a yes or a no. Mm-hmm. So give her a month to train this animal. The fact is that training animals to do any kind of specific task that would be needed for a disability, that's pretty complicated stuff. And that's going to cost a lot of money, right, to get a professional trainer to do it. People with disabilities typically don't have that means, so they resort to trying to do the training themselves. But the fact is that might not be effective training, and so that might not get that dog trained up to be a qualified service animal. So that's tricky. I would like to think the parties would come together and give her some time to get the animal trained, and it's going to be a reasonable time. And if it's not possible, the law doesn't give people everything that they want. It's got to be a reasonable accommodation, and that's probably where that would end up.
Okay, thank you.
Hey, I'm John Reed, interested Columbia citizen. I'm interested in the protection and safety of the existing tenants in a multiple units. For example, let's say you have somebody who wants to buy a duplex, and he's had his horrible experience as a child with dogs, and he's terrified of any kind of animal. Does he have the right to deny anybody, including a service animal, to live in the unit next to him if he's, if it would affect his quality of life?
Well, so a couple interesting things. One, with fair housing law, there is an exception for, it's called the Mrs. Murphy exemption. So if an individual owns up to, say, a 4-family flat, so a duplex, triplex, or 4-unit property contained in one building, like a 4-family flat, and they live in it and they rent out the other units, they're exempt from fair housing law, so they can pick and choose who lives in their unit. Do not advertise it, or you will lose that protection under Missouri law. If you put some kind of discriminatory advertisement out there, your federal exemption goes away. But that'd be the one thing with that person that I would counsel them to be careful that they're not advertising, so no Craigslist ads, nothing like that. And then, yes, they can pick and choose who lives close to them in that particular unit. Other than that, then no, like say if they don't have that exemption, or they live in the unit next door to the 4-family, then that person's subjective fear isn't going to be a defense. It has to be based on an objective assessment of that animal. Now, if that animal put that person in fear because it lunged or it growled, or there was something objective that you could point to about that dog, that would be where that defense would lie. But that person's personal past experience isn't going to be enough as a defense.
Could a apartment owner deny, like, let's say they had more than one unit available in the complex, could they tell them that they couldn't live next to the person who was terrified?
Well, so I'd be very careful about that, and because I'd be inclined to want to try to help everybody out, but what you have to be careful about in that situation, that housing provider, is something called steering, and individuals, we're all entitled to the housing of our choosing. So the person with a disability who has a service animal is entitled to the housing of their choosing. So all units available need to be available to them, and they get to pick and choose. And if a housing provider, even with the best intentions, says, here's a unit by the woods, here's the unit at the edge of the property, this would be great for you, it probably would, right? Or maybe that's where I would pick for my dog. But the property owner taking it upon themselves to direct someone to a particular unit, that's illegal. So I wouldn't suggest that. And I would be very careful in what you say, because if you say things like, oh, this unit's next to Tom who hates dogs, then you get into what Rigel talked about as a discriminatory statement is nothing more than something that indicates a preference or a dispreference to a particular class. So if you are showing someone properties and you're like, just FYI, this unit's great, this unit's next to Tom who hates dogs, so he might hassle you. Well, you might have then just indicated to that person a dispreference against a disability or a service animal, and that would be illegal in and of itself.
One other quick question that was brought up by your comment about being able to pay the rent late as a reasonable accommodation. I'm curious about that because, and I'm a newbie to this area, so pardon my ignorance, but it seems to me that's a result of a bad planning, because
Yes.
if I get paid on the 10th of the month, that doesn't exempt me from paying my rent on the 1st. I just have to take the rent from my pay from the previous month and pay my rent on time the next month. So.
Yeah, and so you get to a point where it is a planning issue, or someone, they didn't pay their rent, so now they're trying to get caught up in a legit way. But those are generally exceptions and not the rule. The general rule is if someone's Social Security check comes on such and such date, 5 days, 10 days, it gets to a point where it's like 30 days, okay, you might just be a month behind on your rent. It doesn't even really become an issue with your typical move-in situation where someone is on disability already, because that all gets kind of worked out with the move-in process. So it doesn't come up all that much. But if something happened and circumstance changed, or it was just as simple as needing that small period of time, a change in the date is a pretty clear-cut, reasonable accommodation, and they're going to get it. So you might as well go ahead and give that to them. You get your full money at the end of the day, at the end of the tenancy, so it works out. But typically, if someone has that come up, we suggest give them the accommodation.
10 minutes to Leah.
Okay.
So I'm actually a law student, so we work in hypotheticals, so I'm apologizing early because it's probably going to be ridiculous. So I actually have two questions, and my first question is, how would anxiety, depression, PTSD, since those are more emotional disabilities, would those still fall under mental disabilities for the Fair Housing Act? And then my second question is even more ridiculous than the first one. So I have a friend whose mom is allergic to dogs and horses. For the ADA, I think is what you said. You said many horses or dogs. She's allergic to both of those things. So how would they work with someone who's allergic to cats, dogs, horses, and about a bajillion other things?
Well, so when it comes to the house, and your first question wasn't ridiculous, any kind of physical or mental impairment. So anxiety, PTSD, depression, all of those are covered under disability rights laws. Now with housing, it doesn't have to be limited to a dog or a horse. So with housing, you have no concerns. With public accommodations, I mean, the law just has its limits. And so the limit is dog with that miniature horse exception. I see cases out there that talk about service monkeys and things like that. So there's other options there. But honestly, to sue under the ADA, it would be a dog. You'd have to be wanting a dog or a horse because that's just the line that was drawn in the sand there. And like I said, you don't always get everything for all people.
Yeah.
There's some limits.
So if someone had those allergies, could they work with legislation to expand that?
And I think that's something that would be good to educate those people making our laws on. Like, what does it matter if it's a dog? Isn't you'd be advocating, isn't the means, that it's a safe animal, but it's providing a disability-related need.
Okay.
I think when you get into the more exotic pets, there's concerns on, I don't even know, but like vaccinations, what if it bit somebody and then who knows what you're going to get? And I'm only speculating that that's the conversation that was had, and dogs were pretty safe, well understood, and so we're going to allow this. And it's a good first step.
All right. Thank you.
Hello, my name's Olive Leffler, and I'm a property manager. You were speaking of documentation in regards to support animals. Do you consider documentation from the internet a reliable source?
Oh, gosh. I think those places should probably face some liability under some consumer laws to take money from people to print those because they're not worth, I don't think they're worth the paper they're printed on. That internet provider doesn't know them from Adam. They're taking, maybe they're just printing it off, but sometimes these places are taking money from people. And I've seen $75. Pay us $75 and tell us you have a service animal, and we'll give you a certificate that looks legit. And if you take that to a housing provider, they might take it. But if you say, no, this person does not have the authority to know anything about you, then that's not a reliable documentation, and that's not going to hold up in court. I haven't say that's been litigated, but I would think it's very hard pressed because it's reliable documentation from someone with authority to know.
That was a great question, by the way. I'm Brett. I'm the AGM at Aspen Heights. We're primarily student housing. So kind of two questions. Sorry. I usually talk really loud, so I never know. So two questions. One, so we have a pool, and we haven't really experienced this too much, but I know you mentioned the thing about allowing service animals into the pool area. We've received guidance in the past, I believe, from the City of Columbia that monitors like the health and safety of our pool to not allow animals into our pool area. We just want to know, I mean, we try and really adhere to these things, so we just want to know, is there, or could there be some liability by, the safety of our pool if we're allowing animals into there, or is that just something we should do?
Right, so I wouldn't suggest that the dog gets to go swimming,
right.
But poolside, if someone wants to be there, I would advise my clients to let the dog be poolside.
Okay.
I've not seen any clear-cut rule one way or another to say whether that's been litigated or or I like HUD guidance, so I've not seen that come down from them. So I would definitely say poolside is something reasonable. I wouldn't suggest the dog gets to go in the pool. I'm not saying that a tenant who has that issue wouldn't file a complaint, and that might get litigated on up to the Supreme Court, who knows?
Sure.
But if I'm advising a client, I would say let the dog sit poolside, but doesn't need to get in the water.
Cool. So I guess in that situation, if we, in general, we have a no pets policy at the pool, but we allow pets in general at our property. If we were to say to someone, you can't have your animal at the pool, and they say, oh, it's an ESA or support animal, obviously we're not going to ask that person for documentation right there, but would it be okay to go in and look at our documentation of that person, ask that person's name, and then look and see if we have that documentation on file that they do have an ESA and that they're not just bringing, they're not.
Yeah, because if it's not apparent, then you're entitled to that reliable documentation. And so if you look in your file and you're like, oh, we don't have any documentation, you're not running afoul of any law. You're doing what's within your rights, right, to say we just need some reliable documentation from someone with authority to know that this, confirming that you have a disability-related need for this animal. Cool. And it's that simple. And you can go back after the fact and do that. That's one thing I also wanted to say is a lot of housing providers, tenants don't disclose when they're applying to rent with you that they have a service animal, and you might even have that. Do you have a pet? Check yes or no, and they put no. And then they show up and they've got 50-pound Rottweiler support animal. And so housing providers think, well, that was very dishonest to not accommodate that, or not to disclose that. And then typically it's followed up by, I would have directed them over here if I would have known they had an animal. And I'm like, whoa, please don't ever do that. Don't direct anybody with a service animal anywhere. But I tell them, they don't have to disclose to you that they have that animal when it's a service animal that they move in. Just like I don't have to put a checkbox that says I'm in a wheelchair or I need a walker. They don't have to disclose it. But once it's there and once you see it and once they're bringing it somewhere that would be an exception to the rule, you're perfectly fine to ask for that documentation.
Okay. And then one other question that's kind of on the same subject. One of these ladies touched on it. We have a lot of people that bring in animals that they say they're training to be support animals. We've always tried to treat them like support animals, but at the same time, a lot of those people don't even say they have any sort of need for that animal other than that they're doing a service by training this dog or whatever. So I guess we're not really sure how to handle that.
Right. So someone who's training a service dog for someone else, noble effort, but that doesn't give them an accommodation to have that animal with their housing. An individual who is disabled gets the reasonable accommodation. So that is something people who do noble work for these support dog agencies and take the dogs in and train them need to consider. You might get a nice housing provider who goes ahead and makes that exception for you. Housing provider can do that. They can do that. But legally required to give them that person is an individual with a disability, so they're not going to get it. And then, like I said, when it's training, it is the actual individual's dog, but they're trying to train it themselves. You get into that very murky area, and I would always advise to give a shot for some training to work, but it does need to be a trained. Like an emotional support animal doesn't need to be trained, so generally that's where that animal, in the reality of things, is going to skate into this housing situation. But if it is, they don't have an emotional need for this animal, it's got some kind of seeing eye dog or something, or whatever emotional. Whatever task she's trying to train it to do, then she can get a chance to train it. If it can't get trained to do the task, then for that disability, like I said, you have to keep focused on it has to be a disability-related need for that animal. And if it's just emotional care and support of the existence of an animal, there really isn't a training issue. People are trying to impose that on her, like, oh, you need to train this animal, but that might even be what's going on. Is she might not need to have a trained animal if it's not going to perform a task, if her doctor is saying, and if that's a housing situation, that she has this animal, it's by its existence, provides her some amelioration of her disability. Training might even just come off the table there, is another way to look at that.
Thank you.
Mm-hmm. Any other questions? All right, well, thank you very much. Well, hold on, I might have some announcements.
Thank you, Amanda. So welcome back, and for those of you just joining us, welcome. Our next speaker is Randy Cole. Randy holds a master's degree in public administration from the Truman School of Public Affairs. Randy worked for Central Missouri Community Action as the Energy Conservation Coordinator, where he oversaw the Department of Energy's low-income weatherization program serving 8 counties in mid-Missouri. Randy is the Housing Program Supervisor for the City of Columbia. He oversees the city's affordable housing efforts as well as other community and economic development efforts funded in part by the Community Development Block Grant Home Program. Randy will be presenting an update on the city's efforts on affordable housing and the city's new Community Land Trust. Let's welcome Randy Cole.
Thanks. I'm really happy to be here, and I think this is a great event that the city does every year, and Rose always does a wonderful job organizing it, and I've just been really pleased so far. My name is Randy Cole, and I'm the Housing Program Supervisor here at the City of Columbia, so I oversee our Community Development Block Grant and Home Dollars. One of our earlier presenters, Rigel, mentioned having to comply with affirmatively furthering fair housing. That'll be a big role that I play the next time we do our consolidated plan, which we'll begin that process in late 2018. In the past, we used to do what was called our analysis to impediments, and I have some of that data here in my presentation today, and I'll touch a little bit on that. I touched on affirmatively furthering fair housing last year, but this year I really want to do a broad level overview of our affordable housing needs and relate those needs to fair housing in our community. And then also touch a little bit on economic integration, or how to address some of those fair housing issues that have been talked about already. And I think that'll tie nicely to Molly's presentation, which is after mine, and I'm really looking forward to seeing that. But then also try to weave this into our Community Land Trust efforts and really focus on this important new initiative that our City Council has helped us move forward with. And then I'll summarize, and we'll have some questions. So I hope to get through this within 20 minutes and leave at least 5 minutes for questions. But if you want to interrupt and ask me questions as we go, that's fine too. So I think it's important to start with the definition of affordable housing. I like to use HUD's definition because it's standardized and used across our country. And it's basically housing for which people pay no more than 30% of their income on their gross housing costs. So for rental, it includes rent and utilities. For home ownership, it will include principal, interest, taxes, insurance, as well as utilities. But yeah, that's the definition I use. And typically, I think of applying this towards households that are less than 80% the area median income. So we're talking about those individuals and households in our communities that may be of lower income. So just kind of a broad level overview of our community. We have about 45,000 occupied housing units. The 2016 family home sold median price, this data is from the Columbia Board of Realtors, was $180,500. If you look back what it was back in 2000, it was much lower. I believe it was around $119,000. So we've seen quite a bit of appreciation. The median rent in our community is about $800, and the median income is about $44,000. We're closer to 45. So when we're talking about affordable housing, we're talking about households that are what we call housing cost burden. And those are households that expend more than 30% of their gross monthly income on housing costs. And looking at our community, hopefully all you can see this, this is a chart that's broken out by income level. On the far left, you have households that make less than $20,000 per year, followed by 20 to 35,000, 35 to 50, 50 and 75, and then over 75,000 gross annual income. So this shows the distribution of households that are what we classify as housing cost burden. And certainly you can see, which makes sense, that those that make less than $20,000 per year are the largest portion of those groups that struggle with being housing cost burden. As we get further down the road in the land trust discussion, we talk about which population should we serve with which strategy, be it providing shelter, providing affordable rental units, or getting people into home ownership. When we talk about the Community Land Trust, we're really going to be focusing those efforts on probably that bar with between the $35,000 to $50,000 range, some of the people in the $20,000 to $35,000, and then some of the people in the $50,000 to $75,000 gross annual income. And looking back at our down payment assistance program, the average income of a person going into that first-time homebuyer program is about $35,000. or not the person in the household. So in thinking about that big group, the people that make $20,000 per year or less, and trying to contextualize what's an affordable housing unit to them, there's about 11,000 total households in that category, or a little more, 11,600. So if you look at what's an affordable monthly payment if they're going to rent, payment and utilities, it would be about $500 per month. And then looking at ACS data on how many units we have that have monthly housing costs of 500 or below, we've only got about 6,300 units. So there's a pretty big gap between the number of units available to the number of households that need that affordable housing. You know, one thing that's not shown in this data is also the quality. Certainly when we have lower rent rates as well as lower home buyer prices, that quality tends to go down, and there's other issues associated with that. Something that was mentioned in Rigel's presentation earlier, and I think Molly will likely talk quite a bit about, is economic integration. So I think it's an important question to pose of how important is economic integration in our community. And I think that the most powerful message of why it's important is its impact on the success of a child later in life. There's been a lot of research done recently, the CHETI data, that verifies this and shows that the sooner a child moves to a more economically integrated community with safe housing that's close to good schools, good healthy food options, parks, low crime, the earlier the move, the more successful they are. So it's really powerful and data that verifies that. It seems kind of common sense. You give a child a good place to grow up, they're going to do good. I mean, it's funny, it's not funny, but we had to do a large, extensive study to verify that. It seems almost common sense. And then looking at the median quality of schools, this is nationwide data. Public housing tends to fall in the 19th percentile, while it improves with our Housing Choice Voucher Section 8 program to 26. People have a little more options. Our tax credits are around 30% percentile. But if you look at communities that have inclusionary housing policies, voluntary or involuntary, the median schools of homes located with communities that have inclusionary housing policies fall in the 40th to 60th percentile. So where they're more economically integrated, they have access to better schools. So kind of look at some data for our community and thinking of schools. This is data from our Columbia Public Schools, and it's the mobility rate, which is how often does a child start and end the school year at a different school, typically due to housing instability. Maybe they've been evicted, maybe they can't meet their bills, or maybe they're doubling up with another family member, so they've had to move. Across the schools, or our whole public school system, the average is about 26%, so that's pretty high. And to think about what happens when a child moves from one home to another, there's usually some processing that happens that takes up to 2 weeks. They're usually at different points in their learning curriculum. It puts them back sometimes upwards of 3 months in their learning. So if this happens every year, that child's going to keep falling further and further behind. So affordable housing and stability is critical to a child's economic success further down the road in life. I attended the National Community Land Trust Conference last year and heard a presentation. This is the guy's book. I'm not getting any kind of proceeds for him selling the book, but it's a good book. His presentation summarized it really well. It was Mark Joseph, and he talked about mixed income developments. He did a 5-year study on public housing in Chicago that really changed how they did public housing from being more concentrated public housing to doing more mixed income developments. And he took a real honest look at it and basically came to the conclusions that it's a great way to do it and probably the best, but there's still some associated challenges. It's not all flowers that everything worked and all the intended goals were met. So there's definitely some challenge with mixed income development or economically integrating the community. Certainly you have issues of NIMBYism or people being concerned about impacts on property values. There can be implicit bias that we talked about earlier, or misperceptions about different populations, or even racism involved. One thing that Mr. Joseph talked about was some of the negative impacts on some of the economic integration that still need to be worked out on how we work on integrating our communities, was that some of the lower income people felt a bit stigmatized or labeled as being that low income person living in that higher opportunity neighborhood. And then they tended to have issues with people gravitating back towards others that they share common backgrounds with. Another potential negative impact was gentrification, where some of this mixed income development had been done under deed restrictions. So eventually those deed restrictions are going to run out. So you've had new development come in, and people of low incomes benefited, but down the road they get displaced, and that becomes a less affordable area. So it's a really good analysis that took a good hard look at is mixed income good or bad, or his conclusion was it's good, but there's still some challenges that need to be worked out, and it's still not quite that silver bullet, but it's a really, really interesting take on the subject. So in looking at our community on how economically integrated, this map, hopefully y'all can see it, but it shows basically a heat map of affordable housing in our community. The darker the green parcels are more affordable units. The darker red parcels are less affordable units, and this is county assessor data that I worked with our GIS department to put together this analysis. And what you can see, it pretty much verified a lot of my assumptions in our community. If you go to the south and southwest, homes are less affordable. We've got some more affordable homes just to the north and to the west of downtown, and then on up to the north and northeast. So you can really see that there is definitely some segregation in terms of affordability of homes. This is a little more closer look on the central city area. You can see Broadway goes out to the west there. You can see parcels below that are more yellow and red. So there's a definite, more expensive housing south of Broadway. And to the north of Broadway, it becomes more affordable. This is a very powerful map to me, and was an analysis we did as a part of our analysis for impediments to fair housing back in 2014. And one thing we're required to do to meet our requirements from HUD is to look at our populations moving, are they being displaced? And this map shows the movement of African American individuals by census block, and it uses 1990 census data and 2010 census data. So the darker red blocks are where African American populations, the number in that block, are declining, and your green parcels, the darker green, are where they're increasing. And what you can see is a definite movement of people, lessening of African American populations in our central city area, a growth more around the periphery, particularly to the north. You see that dark green one up to the north there. That's part of our new strategic plan neighborhood where we're trying to do some work to the north and northeast. So I think this map is much more than just kind of interesting to say, that's an interesting map. I think it begs the question, why are these people moving, and what's the impact? What impact is it having on their lives? What's impact is it having on our neighborhoods, and how we serve these neighborhoods with a different variety of needs? One thing we know about to the north and northeast, especially as we've been going through our city strategic planning process, is there's less neighborhood services and amenities in those areas. So it's really great from my perspective that the city is recognizing these concerns about the far north and northeast, and trying to connect with the neighborhoods and figure out what the city can do to help facilitate access to greater amenities in those neighborhoods. As we transition to talk a little bit about the Community Land Trust, I wanted to talk about the affordable housing continuum. I think it's important to keep that context in perspective as we talk about the Community Land Trust. There's people at different levels of need, and there's different strategies to meet each of those levels of need. We need emergency shelters to help our homeless populations. We need transitional housing as well. We do need public housing, and our Public Housing Authority does the bulk of our affordable housing work here in our community. We need affordable rental. We need affordable home ownership. And then we need to help people get up into market housing. So we need to help people move throughout this continuum, kind of relating back to what Phil was talking about. And as we're talking about the Community Land Trust efforts, we're really going to be talking about getting people into home ownership. So I think it's important when we're talking about any of our affordable housing strategies to think about what are our intended goals. Is it to provide shelter? Is it just to get people off the street? Or are we wanting to provide safe homes for children? Are we wanting to reduce traffic by providing housing close to jobs? Are we wanting to stabilize neighborhoods, build wealth within our families? Even do we want to see it as an economic development tool? I think all of these are different strategies that we need to have along the continuum, but they're important to keep in mind as we think about strategies. So the Columbia Community Land Trust, who all here has heard of our Community Land Trust? I know Ryan has, yeah. All right, so quite a few people. So that's exciting. This is really exciting for me to talk about. I think it's a huge paradigm shift in how we develop and steward our affordable housing in our community. But just wanted to give a broad overview of what community land trusts are and how they operate, and then we can get into some questions. So they're nonprofit organizations. They were started out of the 60s with the civil rights movement. The first one was out of Albany, Georgia, and it was to help lower income African Americans get access to lending, because there was a lot of barriers at that time for lending. But really they started becoming more popular in the 80s, especially in the coasts or our higher cost of housing areas. But more recently in the Midwest, they've been becoming more popular because we're starting to also feel the pinch on affordable housing and thinking of ways to protect our affordable housing. But they're nonprofit, community-based organizations that the main goal is to preserve permanently affordable housing, meaning if we're going to create an affordable housing unit, we need to protect it in perpetuity. So whether we can make sure it stays owner-occupied or for whatever intended use we've wanted it to be, preserve the quality and affordability, and increase neighborhood stability. Some of the benefits to creating additional home ownership opportunities: it creates wealth building opportunities, it stabilizes neighborhoods. People in home ownership tend to be more vested in their neighborhood and stay there longer. And in Columbia, oftentimes the monthly payment can be comparable or less than many of the rental rates here in Columbia. Some of the costs are, it costs more per unit to develop an affordable housing unit that is single family residential, more so than if we're investing in creating a multi-unit rental complex that's affordable. It's also not viable for every household. There's some households that might not have the adequate income or credit score requirements, or just purchasing a house might not be a good investment because what they can afford might not be of good quality, or it might be so far out of Columbia that it's a high cost of transportation and that home may not appreciate over time, so it may not be a good investment. But what the Community Land Trust does is it opens up a new opportunity for home ownership that people otherwise wouldn't have. In the U.S., it's been the primary vehicle for wealth building. The government invested a lot in the 30s and 40s to improve access to home ownership. The rate went from 45% in 1945 to 69% by 2006. But a lot of the government policies restricted certain populations from becoming homeowners, particularly African Americans. A lot of the policies in the 50s and 60s oftentimes did what we call redlining, and I know Molly will get into that here in a bit. But the result of that is you have generations of people, particularly African Americans, that have less wealth than white people in the country. $81,000 is the average wealth for white households, while it's only $8,000 for African American. That's a big difference and a big impact on the economic viability of those households, and it can be a perpetuating situation where the children and grandchildren of those families don't see homeownership as an option or have the ability to get there. So the challenge that we're trying to meet with the Community Land Trust organization is that homeownership is unaffordable for many of our working families, and the affordability gap, or the gap between what it costs to buy a home and the level of incomes in our community, continues to widen. There's also declining funds for affordable housing. If we look at CDBG and home, it's been declining every year since 2007, and this is the primary source of funds that the city has to invest in affordable housing. One good thing, though, is our city council has made it a priority to invest some local dollars in affordable housing the last 2 budget cycles. So that's been a very positive thing in helping us move forward some additional goals. Community land trusts take a long-term approach. by changing the home ownership structure. It changes how the subsidies are utilized. In the past, we might work with a local nonprofit or private developer to develop a home that might sell for $130,000. But what we found is about a $100,000 mortgage is that goal that we think is affordable for a lower income household. So what we've done in the past is provide a soft second mortgage that's forgivable over time, and we get that family into the house. The drawback is there's no guarantee that that home is affordable for the next buyer, and what we found that it's not. There's no guarantee that it'll stay owner occupied, and all that hard work and additional subsidy that we put in to make that affordable homeownership possibility available for one household is gone after that first sale. So what the Community Land Trust does is it locks in that subsidy with the house and says in exchange for being able to purchase this home and have an opportunity for this home ownership opportunity that you otherwise wouldn't have, we will lock in that subsidy and you need to pass it on to the next buyer. They still have every opportunity to build equity on their mortgage as well as recapture some of the appreciation. But the structure is it separates the ownership of the land from the improvements or the structure itself. The ownership of the land is retained by the Community Land Trust organization, and the home improvements are sold at an affordable price. And then the right to use that land is done through a 99-year ground lease that's renewable, inheritable, and there's a lot of education on the front end as to what's the rights of the participant as well as the responsibilities of the Community Land Trust organization. We've toured a lot of different communities that have a community land trusts, and when you drive by and look at a community land trust home, there may be a ground lease authorizing the use of the land, but the house typically looks just like any other house in the neighborhood. There's no sign posted that says community land trust land, don't come on. It looks just like any other house in the neighborhood. So the organizational structure, as I mentioned before, is a nonprofit community-based organization. Mission typically qualifies for a 501c3. Our Columbia Community Land Trust organization is in the process of becoming a 501c3 organization. And I think one of the key parts of the Community Land Trust organization is its board structure. The word community is put into the Community Land Trust title intentionally. This structure models the national structure of Community Land Trust, and we use that here in our community. And it's where 1/3 is made up of community and business leaders, 1/3 is made up of neighborhood representatives that actually live in the neighborhoods where those homes are being developed, and then 1/3 is made up by homeowners. So you have all the key stakeholders at the table making decisions on how housing is developed, what's in the ground lease, and how those properties are stewarded for the long term. That's the approach we've taken here, and it's proven to be two things. More challenging because you have a lot of different interests at the table, but a more effective way of getting at all the different community needs that are out there and establishing a community approach. So the vision for Land Trust organization is to have permanently affordable housing throughout Columbia with different options spread in different neighborhoods, an organization that's representative of the community, and an organization that provides community-based solutions to providing affordable housing in our neighborhoods. We have our first project getting started over on the block of Garth Oak, Sexton, and Lynn. That'll be getting started this summer. I'll be really excited to see our first 7 homes going up. Yeah, I can take any questions.
Cravens, and I was just wondering, can you explain more about the city buy-in and the person buying the home? Do they fully own it? How does that quite work?
Yeah, so the Columbia Community Land Trust organization is a separate entity, separate from the city. It's a separate legal entity. It's a 501c3. Well, we're in the process of getting our 501c3. So that entity will be governed, or is governed, by the community. 1/3 business leaders, 1/3 neighborhood members, and we don't have any homeowners yet, but once we reach 7, that'll trigger the remaining 1/3 of our board to come on board. But we do have some board members that have been past program participants and understand the perspective of our future program participants. But this organization will maintain ownership of the land. The house will be sold to the individual participant, but the right to use the land will be authorized through a 99-year ground lease, which will also stipulate all the rights and responsibilities of the program participant, including what they can resell the house to. So there's a lot of different ways that community land trusts across the country approach resales. Some allow the participant to have a quarter of the appreciation as it goes forward. Some land trusts say you get a fixed rate of 1% every year that you're in there. Some land trusts that want to promote stability in a neighborhood or a long-term tenure of the property might say you get more appreciation the longer you stay in the home. Some land trusts have their resale formula pegged to some kind of consumer price index. So there's a lot of flexibility with the community land trust approach in meeting a variety of needs within the community. But the participant does own the structure. Does that answer your question? All right. Yeah, so I think the Community Land Trust will have a great stabilizing effect on the block of Garth, Oak, Sexton, Lynn. I think we're already having that effect by our involvement there. So the goal would be that we'll have home ownership opportunities there on that block in our central city area, where we'll have people there that are longer for the duration. You know, they're going to be there living in the homes 4, 5, 6, 7 years. The average is a 7-year tenure. So they'll be more invested in their neighborhood. We're also going to have the people that are within these homes, a certain number of them will be on our board. So they'll be there talking about their neighborhood, what's going on, if they have some concerns, how they can get involved in their city. So I think it's going to have a very stabilizing effect because the people that actually live in the homes and live within the neighborhood will be governing this organization. Certainly, there's no silver bullet for stabilizing our neighborhoods. I think this will definitely be an additional tool that will help. All right. Thank you very much.
Thank you very much, Randy. And I'm sure you'll have an opportunity to ask Randy that question some other time. So our final speaker of the seminar is Dr. Molly Metzger. Dr. Metzger is an assistant professor at the Brown School of Social Work at Washington University in St. Louis. She also serves as chair of the Domestic Social and Economic Development Concentration at the Brown School, faculty director for Thriving Communities at the Center for Social Development, community engagement fellow at the Gephardt Institute, and board member at the Metropolitan St. Louis Equal Housing and Opportunity Council. She received her BA in Women's Studies from Carleton College in 2001 and PhD in Human Development and Social Policy from Northwestern University in 2012. Prior to her doctoral training, she worked in low-income housing in Chicago as a social services coordinator. Please welcome Dr. Metzger.
Thank you so much. Well, thanks for that introduction, and thanks so much, Rose, for the invitation. I'm really happy to be here and to really be learning a lot today. So I'm going to cover a lot of ground today. I'm going to talk about a lot of history, about 100 years of history, national context. I'm going to sort of drill down to the local level, talking mostly about where I live, St. Louis, but really see this as an opportunity. I won't get too political here, but you know, in this particular moment with what's going on at the national level and at the state level, to me, a lot of the really exciting work in affordable housing and fair housing is happening at the local level. And so I think it's really important that we learn from each other, and that's why I am kind of here in that spirit of exchange. I'm really excited to be learning about the Community Land Trust. That's something we're looking to maybe start in the city of St. Louis. And so I'll be kind of starting broad and then narrowing in on some of the things we're trying to do in St. Louis. And I'm curious to hear whether or not these are some of the things you're thinking about here, or whether or not they might have some traction. So again, I'll start with sort of a broad overview. I know you heard in the first session of the day about the Fair Housing Act and some new developments with the Fair Housing Act, and then I'll get into a couple case studies from St. Louis. And just with a little bit of data thrown in. So this first graph, if you can see it, is just the increase in income inequality in the United States. So this is something that was really brought to our attention through the Occupy movement, but the data bear it out. So the dotted line in the middle is just overall, what is the gap between the rich and the poor, and how has that changed since the 1960s? So, like the Occupy movement sort of pointed us toward, it has been increasing. The rich have been getting richer. The other two lines are what's called the 90-50 ratio and the 50-10 ratio. And basically what that gets at is how, the rich are getting richer, the poor are getting poor, but where is the distribution changing? And the top line is the 90-50 ratio. And that's basically the difference between the richest 10%, so the 90th percentile people who are, making more income than 90% of the population, and that median household, more or less the average household. And that's where we've seen things stretching out. So it's really about the rich getting richer. And when we look at, Randy mentioned economic segregation, which is, sort of correlated, tied to patterns of racial segregation. That's also what we see driving the trends. That it's actually we think a lot about the problem of segregation, and we think about the problems of poor communities, which are, of course, very real, and we'll talk about some of those issues. But when you look at who are the most segregated groups, it's actually the most affluent people and white people who are more likely to live around people who look like they do. So I think that's just some important context to keep in mind. That first slide was income inequality, and again, some of this it tag teams really well with what Randy presented. That when you look at wealth inequality, the data are even more stark. So it's not just how much income are you bringing in, but it's how much do you have in assets. So these data are a little bit out of date at this point, but as of about 10 years ago, 10% of families controlled about 70% of the wealth in the country, and a lot of this is about home ownership, home assets, and with the top 1% controlling about 1/3 of all the wealth in the United States. And again, to start talking a little bit about how racial discrimination plays a role and the importance of home ownership and disparities in home ownership, the racial wealth gaps are particularly striking. Again, Randy mentioned this too, with the median household assets for whites being over $120,000, whereas for African Americans and Latinos, it's less than $20,000. So segregation, Randy also presented some great maps on this for the Columbia context. Segregation is also an important part of this story. So with home ownership and wealth development being very much tied to where you live and the access to home ownership. So these are just a few select statistics on the Black-White Dissimilarity Index across the country. So that's, again, this is a lot of what I'm saying is a quick overview, and I'm covering a lot of ground. And this is an oversimplification, of course. Black-white is missing a lot of the population, but this is one common metric of segregation in American metropolitan areas. And it's not unusual to find areas, Milwaukee is often at the top of the list. Chicago and St. Louis are up there too, where basically the way you interpret this number is the percentage of one group that would have to move to be totally mixed in with the other group. So in this case, you could think of the percent of Black households who would have to move to be totally integrated among white households, or vice versa, the percentage of white households who would have to move to be totally integrated. So again, still very high, what some researchers call hypersegregation. In Columbia, the number is 47, so about a half of white households would have to move to be integrated within the Columbia region. So I would say, it's not as high as some other cities, but it's still, I would say, too high. And then just really wanted to very quickly just show some maps. Randy also showed some maps that he put together. These maps are all from HUD's Affirmatively Furthering Fair Housing Mapping tool. So I'll go through my maps really quickly, but the great thing about this tool is that it's publicly available, it's free. If you Google AFFH mapping tool, you can go and you can play with this yourself. You can look at, okay, I want to look at these 4 different racial and ethnic groups, or I want to look at these different housing programs, and you can kind of zoom in on different levels of geography. So I'll show you my quick run with this tool, but if you want to play with this yourself, it's online and free. So this first slide is the African American population. Of course, the red boundary is the city of Columbia boundary. So this is looking more broadly across the region. Adding the Latino population, and then the white population. So again, showing that within this broader context, the city is actually relatively more diverse. When you talk about segregation, the most segregated group is the white population, the non-Latino white population. And then this adds, and again, there are about 7 categories in total that are included in these data. But then when you zoom in a little, at a little finer level of detail, you see that even within the city, as you all well know, that there still is racial as well as economic segregation within the city. So where did this come from? This is the link to the mapping tool that I mentioned. So I'm going to go pretty quickly through some of the history, the public policy that generated the racial segregation and economic segregation that we see in a lot of metropolitan areas throughout the country. I'm going to go very quickly through this, but I really strongly recommend 2 helpful essays that have been written that kind of lay this out in more detail. So one is Ta-Nehisi Coates' piece in The Atlantic, The Case for Reparations, and the second is Richard Rothstein's piece for the Economic Policy Institute, The Making of Ferguson. So both of these pieces, they're pretty nicely written, like accessible essays, but they kind of connect how public policies from the federal level on down created unequal landscapes of opportunity that played out in real people's lives. Especially the Coates piece in particular really plays out how did this affect, like real people over the course of the 20th century. So I'm going to talk about just 4 of those policies, 2 at the federal level, and then 2 that played out in many cities at the local level. So the first is the Federal Housing Administration's, the Federal Housing Agency's policy of redlining. So Randy had mentioned the opportunities for home ownership that were made available, especially in the World War II era, and for veterans, coming home from the war, having opportunities to purchase a home for the first time. Well, during that same period of time when we were making home ownership more broadly available, we were also drawing lines around which types of neighborhoods we consider to be mortgageable and which we would underwrite through federal policy. And when we talk about redlining, sometimes people think of that as maybe sort of like an abstract term. It's not abstract. You can actually look. So these are maps across the country: Oakland, Chicago, Charlotte, North Carolina. I tried to do my Columbia research, and I know that redlining was practiced here. I wasn't able to find the map for Columbia. But essentially what these maps do is they define risk. They define risk in the housing market, but they basically create it on the basis of race. So by definition, if you're in an area that's an African American area, and now it doesn't matter if there's wealth in that area or not. So we saw in cities like St. Louis and Chicago, throughout sort of the Rust Belt and then the Northeast, the growth of the Black population over the course of the 20th century, the Great Migration. So you have families moving from the South, often entering the middle class. So you see people, establishing communities, moving into jobs like through the Postal Service, all professions, dentists, doctors, all sorts of professions, and developing income, but because of the existence of redlining, not being able to convert that income into home ownership. There's another great book on this. Beryl Satter is a historian who wrote a book called Family Properties that talks about the way that Black wealth was exploited because African American households, middle class households, were not able to purchase homes, how lenders came in and took advantage of that. But this was federal policy, and this was implemented in cities, including Columbia, throughout the United States. So this was not, when we talk about segregation, it's not just a matter of private preferences, of people saying, oh, I kind of would prefer to live near people who look like me. This is also a matter of public policies shaping what we have access to. Another federal policy was urban renewal, again, especially in the middle part of the 20th century. This was federal money that was made available for demolition, often for the construction of the federal highway system. And the question here again is sort of where is the money used, what communities benefit, and what communities are actually destroyed. So the federal highway system, even though one of the main sort of rationales for developing our federal highway system under Eisenhower was to connect the country for purposes of national security, so that we could transport weapons and soldiers and ourselves across the country more quickly in a time of sort of vulnerability. And what it also did was it paved the way literally to the suburbs. And sprawl that was, again, disproportionately sort of a white sprawl into the suburbs. And meanwhile, when you look at sort of what communities were most affected by urban renewal, so again, urban renewal sounds like a good thing, but in effect, it was really led to the destruction of a lot of Black communities, including in Columbia. On the local level, again, we see prior to the Fair Housing Act policies that are explicitly racist. So it's not, a subtle form of racism like we might see sometimes today, but, in the early part of the 20th century, explicit racial zoning, where it says in this district, African Americans are not allowed. Restrictive covenants were a related practice, which said basically if I move into an area and I purchase a home, I promise there's a deed restriction attached to my house. So when I sell my home, I will not sell it to an African American. And essentially having these local policies in place helps our neighborhood maintain its racial purity and comply with that redlining so that we're not moving into the yellow territory. We're not going to be one of those neighborhoods that's flipping. We're in this codified sort of racist way preserving who lives here. And I'm from the suburbs of Chicago originally. We also had anti-Semitic restrictive covenants in the Chicago area. So again, prior to the Fair Housing Act, and racial covenants were outlawed earlier in the 20th century, but this was public policy. So when we talk about the need for fair housing and the need for housing justice, this is the history that we're trying to confront. I wasn't sure whether or not I should mention this or not. I know this is being recorded, but some conservatives, including the person who is currently in charge of HUD, have called fair housing and this effort that you heard about this morning of affirmatively furthering fair housing, they call it social engineering. Like if we're helping people move or we're building affordable housing in a certain area, that's social engineering. When I think of social engineering, this is what I think of. It's like, how did we get here in the first place? This was not just individual actors, or real estate agents or other people steering, and that's part of it, but it's also this larger structure that we created on a very serious scale. So this is what we're trying to dismantle now. And again, just to briefly, I don't know Columbia as well as I should, but just doing some quick research found work by Dr. Elisa McDonald-Warren, who's now the executive director of the Missouri Commission for Human Rights, who, while studying sociology here, described what happened to the Sharp End neighborhood of Columbia. And she wrote that Black family homes and businesses had been systematically commandeered through eminent domain to make way for the white majority. So again, there have been a couple of great dissertations that have been written on the way that this history has been played out, specifically in Columbia. So that was, one variety of structural racism that kind of got us to a certain place in terms of segregation within American cities. And now what we see, and you heard about this again from the Rigel's talk this morning about disparate impact, is maybe policies that are not as overtly racist on the surface, but because they interact with this history of policies, throughout the 20th century, perpetuate and sort of maintain those patterns of segregation. So we can think about zoning practices, minimum lot sizes. In the St. Louis region, we have some suburbs where it's totally impossible to build multifamily housing. The minimum lot size is almost a McMansion. And so to think, and because wealth is still racialized and because of all those previous patterns, you're not saying, like in the 100 years ago, no blacks allowed, but by saying, that we only have this kind of lot size, you have that impact, you have that disparate impact. Education funding, the fact that we fund education based off local property taxes, again, maintains these sort of separate systems of opportunity. The mortgage interest deduction, again, this gets wonky fast, but if you look at federal spending on housing overall, there are all these conversations about should we be spending it on Section 8 or public housing or mixed income housing, or what do we do, with our affordable housing, the kind of little sliver of the budget that goes towards that through HUD. But really overall, the biggest housing subsidy in the country is homeowners being allowed to write off their mortgage interest on their income taxes. And so when you look at how much money we divert from the budget through that, it totally dwarfs anything that we spend on Section 8 or any other program. So as a whole, our housing policy system is very regressive, and again, it's kind of perpetuating all of these problems that came before. And then another issue, and one that I'll be drilling down a little bit into today, is sort of where we do have money available for affordable housing, where do we cite it? So I'll go a little, quickly through the Fair Housing Act, since I know you got a lot of detail this morning, but often when people think about the Fair Housing Act in the 1960s, they think about making it illegal to discriminate, and they think about the fact that the Fair Housing Act made it illegal for landlords to steer people to different types of housing on the basis of race, or for a landlord to say, we don't accept one group or the other. I'm talking a lot about race, but the Fair Housing Act also, of course, includes other protected classes, including ethnicity, religion, sex, disability, and national origin. There are a number of other protected classes. But since 1968, and again, like you heard about this morning, it's been clarified in the last couple of years by HUD, the other side of the Fair Housing Act has always been about this affirmatively furthering side, that it's not enough to just stop doing discrimination, that we have to look at the policies, that perpetuate these patterns and do something more some affirmative, proactive. So I won't go through the court cases because I know you already heard about that. But essentially, this is where we're at now. And I want to say too, as like a word of hope, regardless of what the next budget looks like out of Congress, regardless of how much money we put into fair housing enforcement, that's obviously very important. But we still have the Fair Housing Act. So even if we don't have as much money funding, from the federal level, funding things like community land trusts, doesn't mean we can't still find a way to do it. And it doesn't mean we don't still have a legal basis for, looking at how public policies play into patterns of segregation. So we still have this tool, regardless of who's in charge of our federal government. Okay, and so what AFFH does, it clarifies the duty to affirmatively further fair housing, taking meaningful actions, in addition to combating discrimination that overcome patterns of segregation and foster inclusive communities. And so basically what it does is it says, entitlement jurisdictions, if you're getting money from the federal government through the Community Development Block Grant, home, and programs like that, you have to do something. It doesn't say exactly what you have to do, but it says that there is an impetus to do something. And again, Randy mentioned going from this AI process to this AFFH. There's all this kind of technical bureaucratic piece of reporting and all that. But the bottom line is that it's not enough to just stop discriminating, that we have to look at what the proactive strategies are in our communities. So I'm going to give you, I have just a couple minutes left, and I definitely want to leave time for questions and to see if any of these ideas would resonate in this community, or maybe not. Maybe AFFH looks different in Columbia. But I'm going to talk about 3 things that we're either doing in St. Louis or that we're trying to do. So one has to do with housing choice vouchers, also known as Section 8. The other is a group I'm a part of called Team TIF, which is a citizen group that's working to reform how we spend our public incentives for economic development and housing development. And then I'm going to go a little bit onto the lending side of the coin and talk about a fair lending coalition that we have in St. Louis called SLECRA. Okay, so just a really quick, Housing Choice Vouchers 101. Section 8, it's a federally funded program. The money goes, is allocated by Congress, goes through HUD, targeting extremely low-income households. So, Randy had mentioned affordable housing, especially when we think about people less than 80% of AMI. For Section 8, we're talking about really the poorest households, so people making 30% of AMI or less. And in St. Louis, that's people making like less than $15,000 a year. Within the Columbia area, I think it's closer to the average Section 8 renter makes about $12,000 a year. Many of them are people with disabilities. Again, there are some differences between our regions. Within St. Louis, the Section 8 population is about 95% African American. Here it's about half white, half African American. But the way the program works is that it relies on the private rental market. So in general, with the voucher program, we're not using it to build housing. There's another section of Section 8 that funds actually the construction of housing. But in general, if I'm a low-income renter and I get in line for a Section 8 voucher and I'm fortunate enough to get one, because there's no guarantee that just because you're eligible, you'll get one, essentially I go and shop around in the private rental market, within some limitations of what they'll pay for, and look for a unit that fits what my family is looking for. And if I can find that and find a landlord who will work with me, the way that it works is that I pay 30% of my income toward the rent, and then the program, and this is, again, funded by HUD, operated by local housing authorities, they pay the difference. And if my income goes up, that means that my rent will go up a little bit, and if my income goes down, it means that my rent goes down. So basically, my housing is staying affordable at that 30% of my income level. This is where people are using housing choice vouchers in the St. Louis metro area. So the kind of seed-shaped geography in the middle, that's the city of St. Louis. And within St. Louis, we're an extremely racially segregated city and region where our north side is overwhelmingly African American. Our central corridor is, I would say, sort of gentrifying but more diverse, and our south side is pretty diverse. But North County, the sort of the red area above the seed shape, that's where Ferguson is located, an area that's becoming increasingly African American. So you can see that the patterns of voucher use very much follow the patterns of racial segregation in our region. And I've done some work just talking with Section 8 renters, trying to figure out, it's one issue if this is where people would prefer to live, and then the question is, well, how do we invest in those neighborhoods and make them higher opportunity areas? But then there's another side of the coin, which is, is this your preference, or was this a case of you only having those opportunities? And so we're kind of trying to work on both of those things at the same time. Like, you shouldn't have to move out to West County or Southwest City to have a good school. We're trying to do it all at the same time. But for this case study, I'm going to talk about, some policy changes that we were able to make to try to help expand the range of options that were available to Section 8 renters. This is just really briefly just to show you that the Section 8 data are in that HUD tool. This is what the concentration of vouchers looks like, again, sort of in the Columbia area and the broader region. So you can see here that in the darker areas are areas with a higher concentration of Section 8 households or housing choice voucher households. And nowhere is it very high. Like, in no neighborhood is it more than like 10%. So even the dark gray areas, it doesn't mean that like most people there have a voucher. But this does show that in areas like the southern part of the city, and then of course a lot of the surrounding region, there is really like no penetration of people using Section 8 into those communities. So we were able to pass 2 bills in 2015 that we thought would expand housing choice for people using Section 8. And I call these like a carrot and a stick. And I know there are some landlords in the audience. My guess is probably there's one of these that landlords would naturally take to. We certainly saw in St. Louis one of these was one that like landlords were very happy about, and the other one was much more mixed. So the one that was more like that everybody agreed on was making it easier to take the voucher as a landlord. So, in St. Louis, the way it used to work was, if you're any kind of landlord, subsidized or not, you have to go through the normal inspections, the normal code enforcement. If you're receiving a Section 8 voucher, you also, and in any city in the United States, if you're taking Section 8, you have to go through the housing authority's inspections, that they want to make sure that they're subsidizing high quality housing. So you kind of have a double inspection process in most places. Well, in St. Louis, we actually had a third set of inspections only for Section 8 renters mandated through the city. So this was not a federal law. This was a local law that we had passed, 15 years ago. I mean, I don't know the history of this, but it seems like probably to try to make it harder to use Section 8 within the city. And everybody agreed this was really burdensome. The landlords hated it. It took forever to get, the renter in because you're having to schedule all these inspections. It's time consuming. Meanwhile, the renter has only a limited amount of time to use their voucher, so this is really stressful. The building division who does the inspections are saying, why are we doing, we're kind of inspecting some places 3 times. In some neighborhoods, these are the nicest units where it's overkill, and we're already stretched too thin. So basically, the housing authority, everybody agreed, this is overkill, this is a misuse of resources. And so this particular policy change just got rid of that extra set of inspections. Just made it a little easier to work with. The housing authority, meanwhile, has been doing its own internal reforms, just making it a more efficient organization. They do direct deposit. So it's these are the things that we're trying to do to make the program easier from a landlord perspective. But then, at the same time, we also made it a requirement within the city of St. Louis that, I shouldn't say requirement, I should say we expanded fair housing protections to include one's source of income as a protected class. So, we talk about the federal fair housing protected classes. Local places can't remove rights, but they can expand rights. So, another example here is for LGBT populations. We do not have fair housing protections for lesbian, gay, bisexual, and trans populations in the United States, but certain cities do, and St. Louis does. So we can expand rights, we just can't take them away. And what we did in St. Louis was we expanded fair housing rights to also include Section 8 renters. And so it is now illegal within the city of St. Louis as a landlord to say no Section 8. And it doesn't mean that you have to house any Section 8 renter that knocks on your door, but it means the same way that we talked about with the example of assisted animals or assistive animals, that you can't treat people differently on the basis of that. So if I have 2 prospective renters, one has a voucher, one doesn't, I can't automatically turn one away. I have to start processing both of their applications. And if it happens that the unassisted renter moves along faster and I don't have to deal with the extra inspections, that's not discrimination. So, there are still some barriers for Section 8 renters. But it does mean that just as a flat-out rule, as a landlord, I can't say, I'm not going to work with this program. We were only able to accomplish this in the city, not in the rest of the region. We tried. It was a much harder battle. But so, this has only been in effect a couple of years, but we're looking to see if this has any effect on opening up parts of the city that otherwise landlords were saying. If you go to Craigslist and you type in as a search term, no Section 8, you see these modest houses, these very nice looking spots, throughout the region that would be a great home for a family using a voucher. So now if those units are saying no Section 8 within the city, that would be a violation of our local fair housing ordinance. So that's case study number 1. That was kind of I will call it sort of a technocratic approach. We were kind of, source of income protections was a big deal, but the inspections thing, this did not take a big, uprising. It didn't take a big campaign or anything like that. It was a lot of people who had been working with the housing authority, the building division, for a lot of years, who all were why does this work like this? and basically just took an alderwoman picking that idea up, proposing some legislation, and it happened pretty quickly. The other two case studies I want to talk about are more sort of involved campaigns and are looking at, I think, in some ways like thornier issues that we're working on sort of over a longer time span. So the second is a group called Team TIF. And basically what we're doing with Team TIF is trying to look at the way that the city of St. Louis uses tax breaks, like tax increment financing is what TIF stands for, and tax abatement, these development incentives that we use to try to attract business development. And some of them are small, some of them are big. You know, we have like big projects like an IKEA, other like large corporate developers that we're trying to bring in. Others are maybe small, a single family home that we say, you know, your taxes get frozen for the next 10 years if you come in and rehab this place. So some of them are small, but in total, they add up. In the city of St. Louis, we've diverted more than $700 million from our tax base to these sorts of programs since 2000. So this is about a tenth of our general fund, or about a fifth of what we contribute to our local school system. So, you know, what we're trying to do with this group called Team TIF is figure out, okay, where are these things being used? With regard to those patterns of segregation, are they making things better or worse? You know, sort of who's benefiting from all of this public investment, and shining a light on that. This slide shows where the TIF projects are located within the city. And so basically you can see that overwhelmingly they're kind of clustered in that central corridor. I wish I had a laser pointer, but basically like at the eastern central edge, that's where the arch is located. And at the western edge, that big kind of gray rectangle is Forest Park. And then in between, you know, on the edge of Forest Park is my university, Washington University, and then St. Louis University is kind of in the middle of the city. A lot of our big investment, our new IKEA, you know, downtown is, you know, of course, like right around the arch. So this is really like the wealthiest part of our city. And this has also been the part of the city that's been benefiting the most from TIF, which is supposed to be used, according to state law, it's supposed to be used in areas that are blighted. But the word blight is a totally subjective term. It's very, very loosely defined by state law. So what we're trying to do is devote these resources, these tax incentives, to the places that really are blighted, the places that really could use incentives. And so who we are, we're a group of advocates. We're all doing it as volunteers. That we're advocating for both government transparency, so being more clear when there's a project that's trying to apply for a TIF or a tax abatement, getting more public input into that process. Is this really needed? Is this amount of subsidy needed? Just being really clear about sort of what's on the table at any given time. And then also applying a racial equity lens. Who's benefiting? How is this development playing into neighborhood change, including gentrification? And just trying to shine a light on that. And we have a couple different goals for policy reform. So this is an area that we're working on. We're not there yet. But on the local level, we're working again to kind of build in laws that make the process more transparent. Like Kansas City recently kind of revamped their website for just providing information about projects that were up for a vote, just to make it easier for taxpayers to understand, you know, what the city was considering. And then another issue here is community benefits. So can we create a system where community residents can collectively negotiate and talk about what community benefits might look like? Maybe that's affordable housing requirements. So if you're getting a TIF incentive and you're building 100 units of housing, you need to set aside 20% of those units for low-income households. Maybe it's something else, you know, but this would be a sort of a community negotiation. But one of the reasons I was especially excited to talk about this particular case study with this group was because we're also interested in state legislation, so it would be very helpful to develop a state coalition around this. Because a lot of the laws that determine how TIF can be used are established at the state level. So again, that definition of blight, right now, more or less anything goes. But if we're really targeting these incentives to places that need them, can we make that definition a little bit more clear? So for instance, TIF can only be used in areas with greater than 10% poverty. That's just a very back of the envelope, a very pretty low bar actually, but so that we're not giving tax breaks to the places that need them the least. So I know that TIF isn't used as broadly in Columbia. I know of 3 recent TIF proposals, 2 which actually rolled out, both downtown hotels. I know just the tip of the iceberg about this, but if there's interest in collaborating on this, I would be really interested to talk in the Q&A or afterwards about this. If you want to learn more, we have a website, and we are very big into social media. So we have a Facebook page where basically what we try to do is turn government hearings that are supposed to be public hearings, but the kind of hearings like nobody ever shows up to unless you're a developer or a lawyer, we are trying to turn out the public to attend those meetings. And so one way to do that is just by making it much more clear like what's actually going on, because sometimes like there is so much alphabet soup, like CDBG, LIHTC, SID, TIF, all this language that's really technical, and it might be really important to people's lives, like can they afford to live in the community anymore? What are their kids' school options? But somehow it gets lost in translation. So what we're trying to do is just kind of boil it down to the nuts and bolts and make it more clear to people like what the city's voting on in different public hearings, and try to get people out and participating. Okay, and then last, I'll talk really briefly about our Fair Lending Coalition in St. Louis. So previously I've been talking about efforts around affirmatively furthering fair housing and the Fair Housing Act. This work actually falls within a different federal law, which is the Community Reinvestment Act. So again, very broadly, if you think about the Fair Housing Act as sort of holding cities or government entities accountable for fair housing, the Community Reinvestment Act is focused on holding banks accountable. So dealing with that history, that ongoing history of redlining, and holding banks accountable for where they're lending, and looking at practices that might be sort of racially discriminatory in the present day. Here is a map of mortgage lending in the St. Louis area, and again, if the green areas are the places of minority concentration, you can see that we have a major redlining problem in St. Louis, that we aren't doing home loans in African American neighborhoods. So this is the issue that SLECRA, our Fair Lending Coalition, is taking on. Their goals are to increase access to financial services for all people, especially those who historically have not had access, and then looking at mortgage lending disparities, branch locations, so where are banks located, where do people have access, and then the high proportion of unbanked and underbanked households in certain neighborhoods. And so again, this is a different approach in terms of how can put pressure on the system, whereas Team TIF is a less formal group. It's all volunteers. We don't have any funding. We just work with our own. We work with like free resources, publicly available data, and we use like Facebook and Twitter and things that are free. SLECRA is a more formalized organization. They are a coalition of existing, mostly 501c3s, community-serving organizations, a lot of organizations working in the area of financial capability, and led by EHOC, which is our region's fair housing agency. We just had our conference yesterday in St. Louis. And so a lot of this, it's data-heavy work. So they conduct analysis of banks' CRA activities. So they look at the lending records and other work that banks do to comply with the CRA. And they essentially work with the bank regulators to hold banks accountable. They write public letters commenting on how banks are doing. And they basically have I would say, broadly speaking, a two-pronged approach. They'll work with banks. If banks have not been lending to African American households, they'll say, hey, have you advertised in the St. Louis American, which is our historic black newspaper in St. Louis? And banks might say, well, we never thought of that. Okay, well, that's a good first step, right? So they'll work with banks and help them think about strategies, but they also have the threat of a lawsuit. And especially if it's an upcoming merger or an acquisition of a bank, these sorts of complaints could really hold things up. And so they've had some big wins out of this strategy over, and this is actually doesn't account for a big win that they had recently. So several $1 billion in community development loans and investments, programs that banks are sponsoring around financial empowerment, and 7 new full-service bank branches in African-American neighborhoods, with 3 more coming soon. So SLECRA is our St. Louis Equal Housing and Community Reinvestment Alliance. NCRC is another great organization to know about, the National Community Reinvestment Coalition, that does a lot of training and support and data work, puts out great publications on this issue of fair lending. So I didn't leave as much time as I wanted for Q&A, but we still have a few minutes, so I'll open up to questions. Yeah.
Further,
Right. Right. So that's the first I've heard of it. And I think this is an area where, the first step would be to establish source of income protections, because most places it's not even illegal to say no Section 8. If a landlord doesn't, that's not considered discrimination. So for instance, Columbia does not have those sorts of fair housing protections. So that, I think, would be the first step. Another good resource here is the Poverty and Race Research Action Council. They have basically a list of all of the different municipalities and, in some cases, states throughout the United States that have implemented these laws. They do structure them differently, so you can see, how different places have rolled them out, so that you're not recreating the wheel. But no, thank you. That's good to know about.
Try to talk this time. My name is Eugene Elkin. I live here in the city. I am a disabled individual. I helped bring Habitat for Humanity here in 1988 with the name Show Me in front of Show Me Central. We're standing with more than 140 houses as this just a few days ago I got this update. I did go in St. Louis in the last few days and see IKEA, which I kept saying, what are you talking about? Anyone that wants to make the trip to St. Louis, it's well worth looking at. General description, what type of store would you say it is?
They sell home furnishing. It's a Swedish-owned store that sells pretty affordable home furnishings. It's huge.
Huge.
And yeah, they also have food. They have some great Swedish meatballs. Yeah.
As a low-income individual, taking other low-income individuals in to see that particular project, I did not know their focus. They were wanting to go to an art museum. Back to Columbia. Those of us on low income, I being disabled, have worked for the homeless for the last 8 years. I stepped up in front of city council when I was faced with it. I also participated in a group that formed a law for mobile homes, and that's what they were trying to destroy at that time. We still have not had any perpetuation of low-income housing. When we started losing our mobile home courts, St. Louis did too. The only law we got was they must give a 120-day notice before the closing down of any mobile home. Did I say 120? 6 months. 30 times. Tells me I'm getting tired. Point being that here and across our nation, I'm listening to a radio talk show, and the lady kept stressing, we need to start speaking low income. We've chosen affordable housing as 130,000. We, the low income, don't know that figure, never will, and we will live at this low rate until God takes us away. But in Columbia, Missouri, we had the issue of homelessness come before. I listed the entire neighborhood, and in the end, it was said we need shelters for men, women, men with children, and women with children scattered through our entire city. As you go forward in any of your respective areas of trying to solve this, we need to learn to pick up the word low income as we, the intelligent, speak. We choose bigger, better words that the low IQ doesn't pick up on or doesn't make ourselves very explanatory. Just because I've been to college, I do not work.
Right.
I try to get more people to understand about disability. You can be just fine today and be disabled tomorrow. It's time for our government to wake up. You're a part of the system, please. That speak up for the low-income people of the future. Thank you.
Yeah, here. I mean, that's absolutely what I'm trying to do. And I absolutely agree. A lot of the housing that we call affordable housing, like affordable for whom? So, and this is a debate, people talk about, should we call it low-income housing, affordable housing? Should we talk about workforce housing? Because, Randy had mentioned the not in my backyard attitude and people, there being all this stigma around low-income housing. So maybe if we call it something different, people will think about it differently. But I absolutely hear you. And I mean, I think one of the scary things right now with what's going on at the federal government is that a lot of the federally funded housing programs like Section 8 and what's left of public housing are for people at the lower, people making $10,000, $15,000 a year. And the state programs are more for people making like $30,000, $40,000 a year. And right now, there's just a really big question, like what budget's gonna come out of Congress, and could that take away a lot of those federal programs? And so, thank you for your point. I really agree. There's a huge need at the lowest end.
If the landlord needs help in, like you've said, different tax breaks or whatever puts that person of low income into his property, not Section 8, just increase the communications of dollar for dollar.
Mm-hmm. Thank you. All right. Thank you. Thanks.
Thank you, Dr. Metzger. We'd like to thank the Missouri Commission on Human Rights, the City of Columbia Human Rights and Disabilities Commissions, Anthony Holmes and the Columbia Apartment Association, Lynn Limbach and the Central Bank of Boone County, and the Columbia Housing Authority for sponsoring this event. I would also like to thank all of the city staff who assisted with this year's program. Finally, and most importantly, we would like to thank all of our speakers who have graciously volunteered their time to prepare and present these outstanding presentations today. Thank you, Professor Rigel Oliveri, Amanda Biondolino, Dr. Molly Metzger, and Randy Cole. Please complete the surveys and place them in a box on the registration table just outside. Thank you all for coming, and have a great weekend. Thanks.